Hey yo, welcome back one more again. Peace, family. Welcome back to Flesh of the God. Shout out to the early ones in the building. Brown Sugar Babe, No One, TSC. I see y'all. Appreciate you, family. As promised, we back again with the closing arguments. Had to go take care of a couple things, but we gonna have to knock out these closing arguments because the rest of them will be tomorrow, and I want to get these out the way. So I appreciate everybody who coming in. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend, and thumbs up on the way in. Yeah, yeah. Do it again. Thumbs up again. Thumbs up. Get us in the algorithm, family. Let's go.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
The music and beat are catchy.
Now maybe
Gaining millions of views and plays on YouTube and streaming services.
Right. If you and only you have the authority to grant him immunity, how is he not peculiarly within your control?
Well, first of all, he could still invoke. I mean, if every person that we conferred immunity that had a pending charge, we would take sworn statements of every criminal defendant, confer use immunity, and then we know what their testimony is going to be at trial. The invocation is anything he say can be used in his pending criminal case. Me giving him use immunity doesn't absolve him of that. He still has a right of not against self-incrimination. So this whole concept of conferring immunity, maybe that works in a case where there's not a pending charge, or we give transactional immunity, but this is a collateral matter that has nothing to do with this particular case. It is impeachment on a collateral matter. As the court has pointed out, Raekwon Howard could be subpoenaed as easily as anyone else could be subpoenaed to come to this court and testify about what he knows about this case. And that is not peculiar within the state. We even try to do all these things. They could have done it. We could have had this hearing on this Gantt issue that came up in the middle of trial. But whether or not they're calling a witness to impeach about whether or not he shot at one of the state's witnesses is so collateral to this case. It should not be admitted. They should not be allowed to make that argument. It implies that Raekwon Howard's answers would not be consistent with Mr. Barner's, which in fact they are.
All right. So I think I've heard enough from both sides. Based on the Lena case you gave me, I'm going to allow you to make the arguments as to the witnesses you did call. Based on Halliburton, I'm not going to allow you to make that argument with Raekwon Howard. I'm not finding that he's peculiarly within the province of the state to have been able to call him despite your arguments regarding immunity. I am also going to find that that is a collateral matter. I understand he's been accused of trying to kill two of the witnesses in this case. That doesn't make it material to this alleged phone call that he may or may not have made or had with your client. I do find that to be collateral, not material, and it would be in violation of Halliburton. So I won't allow you to make that particular argument as to Raekwon Howard.
The absence of evidence is not the evidence of absence.
What?
And let's try to avoid as many sidebars as we can, please, during
They said Raekwon out there trying to kill two witnesses.
this closing so we can have a
Shout out to today's stream sponsors. We're going to keep it rolling from earlier. That's still today's stream sponsors. Allie, Joni Ford, Chama Black is Golden. Appreciate you, family.
smooth and orderly closing argument for all parties. So at this time, if there's nothing else, can we bring out the jury, please?
And they have to rest, I think.
They do. They have to rest, and they're going to introduce their CAD report and then rest, correct? Okay, do you have that? I have the exhibit here. Let me hand it to you so you can formally move that in the presence of the jury. That's defense exhibit number 4. Okay, let's bring the jury out, please.
absence of evidence is not the evidence of absence.
What?
And both defendants have rested their cases. The attorneys are now going to present their final arguments to you. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments as they are intended to aid you in understanding the case. Now, each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing. And of course, a little unusual in this case is we have two juries. So the state is going to give one closing argument to both juries. Then Defendant Whitaker will give its closing argument only in the presence of Defendant Whitaker's jury. You all will then be excused, and then Defendant Hakeem Robinson's jury will hear the closing argument from Mr. Robinson's attorneys, and then you all will be excused. This is our tentative schedule. So then I think that will take us through the rest of the afternoon, and tomorrow we will return at 9 o'clock for Defendant Whitaker's jury so I can instruct you on the law. Tomorrow, Defendant Robinson's jury will return at 9:30 so that I can then instruct you separately on the law, and then you will retire to each deliberate your separate verdicts. So while we are now nearing the end and likely will not be here, well, I don't know, but we had told you this would take to Friday. We might actually end a little early. I do want to still stress the importance that you must not talk about this case among yourselves or with anyone else. This case is not over yet. You still have arguments and the law. Those are two very important parts of the trial. So do not discuss this among yourselves until I excuse you to deliberate your verdict. But at this time, I'll call upon the state for its joint close. Thank you.
Family, co-defendants, Leroy Whitaker, Hakeem Robinson, their good friend Dominique Varner, and a few others, fulfilled their collective, premeditated design, their plan to execute Charles McCormick. What was the reason? It was personal. There was no justification for it. Charles McCormick did not deserve to die. He made a song. That song was disrespectful. But it's not just that it was a song. It's what the song referenced. Specifically, who it referenced. Willie Addison. Because Willie Addison wasn't just another person. You heard from Hakeem Robinson's sister who Willie Addison was. He was blood. Brothers. And Leroy Whitaker is Hakeem Robinson's cousin. Their blood. And Willie Addison's blood was spilled on January 15, 2019, along with Abdul Robinson Jr., Hakeem Robinson's brother, Oregon Williams, Abdul Robinson Sr., who you know as Blue, and a couple other people in the vehicle. Hakeem Robinson and Leroy Whitaker were not in the vehicle, and you know that from way back in the opening statement. I wasn't hidden from you. They didn't have to be. Because again, it was their family that was in that vehicle. It was their family that was killed, and it was their family that was severely injured. It was his brother, Hakeem Robinson's brother, that was shot in the head. And in the hospital for months. Had to learn how to walk again. And then Hakeem Robinson and Leroy Whitaker listened to Smoking on Willie. And it's not just the lyric of Smoking on Willie, it's who's singing it. Because it's Charles McCormick, who's part of Six Block. Keep in mind, ATK, Hakeem Robinson, Leroy Whitaker, they don't like Six Block. They're rivals. They hate one another.
Smoking on that Willie. What up, no one? I see you. Tat, tat, tat. Clouds in the building. I see you. Appreciate you, family. Burn the house down.
A rival, someone you hate already, smoking on your brother. And that lyric bears its way into their minds, into their memories, into their blood. They're not going to let it go. They're not going to let something from Six Block go regardless, let alone something so personal as family, brothers, blood. Can't let that go. Some exhibits, States 40, States 227. On the left, Hakeem Robinson's Instagram account. Rest in peace, big brother. You know I stood on all 10 about you. Don't speak on Willie. That's exactly what Charles McCormick did. He spoke on Willie. He said, smoking. And then, next to it, on Abdul Robinson Jr.'s account, at the gravesite. When is that posted? Take a look at the date.
No. They gonna play that as soon as I walk away and get something to drink.
2 days after the murder of Charles McCormick, which took place coincidentally exactly on the 1-year anniversary of Willie Addison's death. 365 days in a year. And he dies on January 15th of 2020. The bullseye on the calendar, and he was the target, and they took him out. Dates 229. That's just a short clip of the song that you all heard. That's probably the most important part of it. And I guarantee you that that lyric, as much as you all remember it from hearing it before, those who knew Willie, who loved Willie, who considered him blood, they heard that every day. Here's another photograph, States 229. Willie Addison, law student. Surrounded by Hakeem Robinson, Abdul Robinson Jr., and there's Torgon in the middle. Family. You heard from Hakeem Robinson's own sister. They all heard about it. They all knew about it. And they, Hakeem Robinson, Leroy Whitaker, were upset. They were really upset. And you know who else told you that? Father, Abdul Robinson Sr. And if you could set aside your personal feelings and emotions regarding that individual for a moment and just think about that one statement that he told you. We were aware of that song. We were upset by it. Hakeem Robinson and Leroy Whitaker were upset by it. Abdul Robinson Jr. was upset by it.
Hey, FFS, Judge do be looking mad. What up, though? What up? Hey, it's funny to see her react to some of the things they be saying, too. She be like, really, bruh? She be like, really?
Detest Abdul Robinson Sr. He could still be telling you the truth. And how do you know that statement from him is truthful? because Akeem Robinson's sister from that witness stand earlier today told you the exact same thing. Just as she corroborated him that Akeem Robinson was living with him. They were all living at the same house on Brown Jersey Court. January 6, 2020, this is States 30. Recognize those faces? Cousins, January 6, 2020. In a criminal case, you have heard, and the judge will go over the law with you at the conclusion of this, it is the state's burden. We have to prove the charges. We have to prove them beyond a reasonable doubt. The key term there is reasonable doubt. It's not beyond all doubt, not beyond a shadow of a doubt, a forced doubt. It's beyond a reasonable doubt. You would have to have a doubt that is reasonable. But if you have an abiding conviction of guilt, the case is proven.
It's crazy they always talking of that beyond a reasonable doubt, but really, it seems like the defense always got to prove that they innocent. It's like it's not up to them. It's like it's not innocent until proven guilty. Like even if they don't actually prove it, they just got to make it look like you did it, and then you still guilty. So that's where beyond reasonable doubt come in. It's like you ain't proved beyond a reasonable doubt. So I don't know. This is my thoughts.
I'm going to suggest to you that has been proven, and it's not even close. We're going to go through the evidence here, but just very, very quickly. I'm not spending much time on this. Count 1, first-degree murder. Both Akeem Robinson and Leroy Whitaker have been charged with that, as you know. I don't believe there's going to be any debate, there hasn't been throughout the trial, that what happened to Charles McCormick on January 15, 2020 was first-degree murder. It's captured on video. Person gets out, runs him down, and guns him down. It's not justified. There's no defense. It's clearly premeditated. So there is no doubt, no debate that this crime was committed. The one and only question is, who is responsible? And if you remember back in opening, brings us back to two questions. For January 15, 2020, where were they and what did they do? That's what the state has to answer for you through the evidence. And the state has answered that with a mountain of evidence in this case. One additional instruction I want to talk about briefly before I get into the evidence is the instruction on principles, which I anticipate you will see from the judge. And that is because more than one individual was involved in this crime. One person pulled the trigger, but not just one person is guilty. Because this wasn't a crime committed by one person. There were, as you all know based on the evidence, 3 individuals in that Nissan Altima. 3 individuals.
There go another thing they don't use with police officers is that they don't say that when it's a cop arrest and there's a bunch of cops around watching them kill somebody, they only convict the one officer, usually. But sometimes they do the other. Actually, recently it's starting to change as of people getting cameras and caught on body cam. But before that, they never did.
And they all, to a man, wanted this to happen. When you go to commit a crime like first-degree murder, Ryan, you don't bring along staff. You bring along co-defendants, family, those who want the same thing that you want. And so the law of principles is, even if you didn't pull the trigger, you are still guilty if you intended that crime to occur. And you did something, said something that encouraged the other individuals to commit that crime. You intended the crime to happen, and then you did something or said something that encouraged or assisted the other individuals to complete that crime. And then you are to be held accountable just as if you were the one who physically pulled the trigger. So let's talk for a moment about the evidence. There were witnesses in this case, because this did take place at a shopping plaza on a Wednesday just before 11 a.m. But it's a very large shopping plaza. And you can rely on your own memories as you deliberate and talk about the evidence and the witnesses and their testimony, and look through the exhibits, including the video. And I encourage you to look closely. Almost every single one of the witnesses in this case were very far away. They were at the other end of the shopping plaza, away from express employment. There were two witnesses who were very close to what happened. Ashita Saunders, who owned and was working at Express Employment, who knew Charles McCormick, who her company was helping him get a job, said goodbye, and you recall what she told you she said to Charles McCormick as he began to walk out the door. You remember? A good day out there. And she stood at the door, and she watched through the glass as the person she knew, who had just gotten a new job, walked towards the parking lot where neither one of them knew Hakeem Robinson, Leroy Whitaker, and Dominique Warner were waiting in that stolen Nissan Altima, a car they had no right to be in, but they wanted a car that couldn't be connected back to them. And so they waited. And that is where States 187 comes in.
That's the police knocking on something.
Miss Saunders, you can look at States 187, still see the front door of Express Employment. And you can kind of see through the glass where that desk area is where she said she was standing, just as Charles McCormick began to walk outside. And she told you she was there, and she saw from the corner of her eye that shooter, that gray and black Nike hoodie, come running towards the parking lot, from the parking lot towards Charles. And Charles ran back initially to the front door of Express Employment. And then, as you see in the video, he turns. What did she tell you? He's coming towards the door. He locked eyes. I see him, he sees me. So he turns. He had a choice. He could have run inside that public office, putting everybody in there and putting Miss Saunders at risk. But he didn't. He ran around the corner and never made it very far. What did Miss Saunders tell you? I saw them. Couldn't identify anybody. Can't identify Hakeem Robinson because his face was covered. 79 degrees outside, but he's wearing a hoodie and it's pulled up and his face is covered. And she gives a description. She says, looked like he had some hair underneath the hoodie. Wasn't a low cut. And we all know Hakeem Robinson did not have a low cut back in January 2020 because we have video. We have photographs showing exactly what his hairstyle was like in the days leading up to this. And she said, I can't put a number on it. She didn't say the shooter was tall. She didn't give a number. But what she couldn't do, what she did do is say, Charles McCormick, the person she knew, the person she just talked to, the person she just walked out her door, The shooter was bigger than him. Was taller than him. Not as thin. And how tall was Charles McCormick? According to the medical examiner, 5'10".
Objection, mischaracterization of testimony.
Overruled.
5'10". And the shooter was bigger than him. She got a clear front row seat to that event as that shooter, Hakeem Robinson, chased Charles McCormick down right in front of her. Close to this. It's not strangers. It's not 30, 40, 50 yards or more away. It's right there. And it's someone she knows. Shooter was tall, was bigger. What did Victor Kruger say? He doesn't know anybody. He just happened to be checking out his mail. He's sitting in that truck. They run past him. And again, this all does happen very quickly. What does he say? Shooter to me looked like, I don't know, just under 6 feet, maybe 5'10", 5'11". 5'11" or 6 feet. An inch. An inch. You know how tall Hakeem Robinson is, 6 feet. Just a tad over, barefoot, according to laser scans. Victor Kruger could be 5'11". Pretty close. Again, keep in mind, shooter doesn't stop, say, measure me. He's running and gunning. This happens very fast. But the two closest witnesses, the two clearest fields of vision, both say very consistent descriptions. Bigger than Charles, 5'10" according to the medical examiner, and Victor Kruger, 5'10", 5'11", maybe just under 6 feet. Very, very consistent. Parking lot, 187. This is a still shot. If you have the video, you'll be able to look at it. You see all the witnesses? You have to squint. How far away are you? You know how tall they are? Keep in mind it's a video. But do you have any idea how tall those people are? You can tell what they're wearing. And then this happens in 10 seconds or less. There's more gunshots than there are seconds that it takes for this crime to be completed. And you hear from a few witnesses who are way down there by Bailey's. Mr. Williams. Well, the guy looked like...
Put a little bit more speed on this guy right here. Because you already know how it do when the state get on the stand.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
Maybe he was crouching. You know what happens when you crouch? You get a little small. Maybe 5'8". But then what did he say? Although sometimes I see people and think they're smaller than me, I walk up and, what do you know? They're taller than me. Jarvis Roberts says he's at least 25, 30 yards away. Saw it for about 2 seconds. That was his test for 2 seconds, because he hits the ground. He's way over there. Maybe 5'8", 5'9", somewhere in there. 2 seconds of an individual running and gunning, not standing straight, not standing up, and you're 30 yards away, which automatically means the object appears small. Common sense. The further you get away from something, the smaller it looks. Anybody ever had an eye test? A little tree in front of you, where they blow the puff of air, it starts getting further and further away. Hakeem Robinson on January 2020. There were some questions. We don't have photographs of him when he was arrested. See what he looked like.
Even the judge looking like, man, are y'all believing this stuff right now? She thinking about them cookies she left in the back.
Well, he got
Or her
arrested
glass of wine like Whitaker.
September 2020. What he looked like really doesn't matter. You know what matters? What he looked like on January 15th of 2020 when this murder took place. Defense 3. January 14th, 2020. The day before their plan was fulfilled. Willie's Day. This is creepy. Hakeem Robinson, what hair? See the legs? Still defense 3. Same day. Keep in mind, the individual in red, sergeant that testified, said he was what, 6 foot, 300 pounds at the time? Himself, not Hakeem Robinson. There's Hakeem Robinson. Dates 2:30, January 5th, 2020. Two individuals, I think everyone will recognize. Leroy Whitaker, and that's Hakeem Robinson. And the over. Leroy Whitaker's 5'6" on the laser scan. Clearly shorter than Hakeem Robinson. And then you put them side by side, and Hakeem Robinson starts bending over. Still, January 5th, 2020. There they are together. Hakeem Robinson, Leroy Whitaker. Cousins, blood. Approaching Willie's Day. And look at the hoodie on Hakeem Robinson. That shape on that head looks somewhat familiar? Anything any of you have seen in this case? About now, states 187 and 230. Hakeem Robinson, Leroy Whitaker, left and right. And in the middle, the shooter. Wearing a gray and black hoodie. Gray and black hoodie you have all seen and will see again. Worn by Hakeem Robinson. Pretty good shot at the firearm, too. We'll come back to that. Dates 248. Hakeem Robinson's height, measured by lasers, 6.0302 feet barefoot. And if you recall, there were some questions of the expert about defense counsel lacrosse about telling he was going to get a measure for his height.
Bruh.
You tell him to stand perfectly straight, put his feet together. Keep in mind, those are two things that Judah never did for any of the witnesses that the defense would like you to believe their estimation of. But it's simply spreading your right and left foot apart is going to affect one's height in any observable way. How in the world is running going to affect it? It's going to make you look smaller, right? And to the right, you see Leroy Whitaker and Dominic Varner, 5.6233 feet, 5.5873 feet, very close to one another. Stage 248, still shot from the dash cam.
That same
But you just lied. Stop it. Stop it.
Charles McCormick and the shooter, side by side. Does the shooter look a little bigger, like Ms. Saunders said? How about height? Ignore the head, but the shoulders. Equal distance from the camera, almost same body position. 5 foot 10 Charles McCormick, Hakeem Robinson. Still states 248. You saw and heard from the expert who did the laser scans and then the 3D kinematic model. Shooter on the left, Hakeem Robinson's body scan model. Right? This shows shooter, Hakeem Robinson, the shooter's kinematic model, and then 3D laser scan Hakeem Robinson, Leroy Whitaker, and Dominic Varner.
The evidence is going to show that anything that I may have said, they exacerbated it.
5.7 feet excluded. Doesn't match up. Hakeem Robinson, not excluded. Stage 243. This is on November 25th, 2019. Gray and black hoodie. Keep in mind, it's not that Nikes aren't owned by other people. And if all the state had was this photograph, this video of Hakeem Robinson in a similar black and gray hoodie, it would be still black and white. But it's not. It's just one piece of the evidence. And you have to look at all of the pieces in totality. And they all point to Hakeem Robinson and Leroy Whitaker. Page 197.
It's KSOO.
Black and gray hoodie. See his hair?
TSC said, I can't take this no more. I'm about to turn this into a slot machine in this mud. I ain't mad at you.
This is the Hanging Out music video that was filmed on December 11th, 2019. A month before the murder of Charles McCormick. And look at the firearm in Hakeem Robinson's hand, his right hand. Fairly distinctive looking, I would suggest. And look at the map, the date of where this video was filmed. You can see it close to March. Where did Abdul Robinson Sr. say? He said, I was there when that was filmed. Over there by the chart house. Right over there, in that same area. He knew where it was filmed. It's filmed on December 11th, 2019. Going back to the expert's testimony when he did that comparative analysis between the firearm depicted in that music video, as well as a known firearm he went out and procured for his testing, which is in the center. And then looking at the images from the dash cam, the points of comparison. Looks similar. Even if you ignore the expert's testimony and you just look at these images, what does common sense tell you? What do you see with your own eyes? The Nissan Altima. This is one of the most important pieces of this case because it was stolen, not owned by Hakeem Robinson or Leroy Whitaker or Dominic Varner. So a car you should not have been in, there that is something that should not be. And you know beyond any doubt that that Nissan Altima was the car used to commit this crime and flee from it. You know beyond any doubt that it was occupied by those involved in this crime. States 77 and states 187. On the left, that crashed Nissan Altima after it fled from Officer Collins. And on the right, a still shot from the dash cam showing the car that was used, occupied by those who are responsible. Same car. It's 187, this is just a few seconds.
That's the car right there, right there.
Victor Kruger. He saw the car, saw the shooter get back into it, and as you hear, that's the car right
That's the car right there, right there. That's him, dag nabbit.
The absence of evidence is not the evidence of absence.
What?
Yo, big shout out to TSC. Dropping the $2. I appreciate you, family. Hey, you all good, man. You know, every now and then, they be doing too much, and you gotta hit them with it. So I ain't mad at you, TSC. Let me see where you at. Let me highlight you. TSC, there we go with the emojis. I see you. I appreciate you. Y'all show some love to TSC. TSC, what's your emoji gonna be? You gotta let me know. I can add you in. Appreciate y'all. Y'all hit the like, hit the subscribe. Oh, and she dropped a gifted membership while she on the screen. Drop some coins for TSC. Appreciate you, family. Y'all show her some love. Show her some love. Drop some of the heart hands. That's one her thing. Yeah, the heart hands. Yep. Shout out to TSC. Appreciate you, family. Let's get back into it. Y'all show her some love. She's like, nigga, I need a break. These prosecutions be doing too much. Way too much. For no reason. Appreciate you.
right there. So there's no doubt that that Nissan Altima was the one that was transporting the guilty from that scene. Let's talk about Officer Collins for a second. He followed that vehicle, not knowing Charles McCormick had been shot and killed, knowing shots had been fired. So he pursued it, turned his lights and sirens on, telling that vehicle, the occupants, to pull over, to stop, and they refused. Garner, who admittedly was in that car driving, admitted to driving recklessly, reaching very high speeds, going through a residential neighborhood as he was trying to get away. Get away himself, but also those who were with him, his friends. Hakeem Robinson, Leroy Whitaker. And Officer Collins, because part of the testimony and the cross-examination has to do with the description he gave. That he advised on the day of this incident that the shooter that he saw get out of that Nissan Altima running west, 5'5", 5'8", 5'9", somewhere in that range. But where was he when he saw that individual? And on the map, you see 1, 2, 3, 4 little addresses. Number 11233 Townsend. That's where the Nissan Altima crashed. Officer Collins testified he was further up than that. 1 Townsend, just past Alderman, that intersection with Townsend. And when he saw the person running, he was about half a football field away, about 50 yards. They saw him for about 2 seconds as he darted across the street. I think we've already covered, but what happens when you're at distance? What happens when someone is running? If you're small. And then factor in, it's a 2-second glimpse. States 80, that Nissan Altima looking back towards the direction that Officer Collins was coming. Based on the map that you were just shown as an evidence, and this perspective, can you even see where his car would have been in this photo? Because he was further back. Just use this visual as context. You see a car, has a patrol car at the top of the screen. Doesn't look that big. That's that. Houses. Imagine being further back and looking at an individual fleeing from the Nissan Altima Sienna for 2 seconds. States 190. Still shots from the Bellevue video that you saw, that's in evidence. You can look at it again. And when you look at it, and you can take note of these times if you want. At 11:23, the shooter runs between the houses and passes that car. Camera doesn't move, car doesn't move, just the shooter. And then look at the image on the right. 11:06:05. Almost 3 minutes later, that's Officer Collins. He wasn't right up on them. And you saw Officer Collins. 6'4", he testified. So look at the 2 images, and on the right, Officer Collins, as he goes past that same vehicle. How do their sizes compare from this image? Is the shooter consistent with someone who's 5'5"? Or is it more consistent with someone that's approaching Officer Collins? Right. Someone closer to 6 feet. Maybe 6'1" with shoes.
That would be the right.
Going back to
the right, left. Excuse me, the right, left side, front.
Okay. That Nissan Altima, states 87. It's not just a car, but it's what was found in it. DNA, fingerprints. On the Glock, the top of the slide, not on the handle, not even on the front of the slide, on the rear of the slide, fingerprints belonging to Hakeem Robinson. His prints on that gun in that car. Now, the analyst can't say at what point in time that fingerprint got put on the gun. Tommy Carter can. The expert couldn't. But common sense tells you, based on even the line of questioning, fingerprints can get wiped off. They can get wiped away. You're going to find a fingerprint on the slide of a Glock left behind in a car that the suspect's just fled out of. But that print, maybe that's been on that gun, and that gun's just been passed around. And yet you get a print on the top slide, clear enough to identify, and it belongs to Hakeem Robinson, who, coincidentally enough, DNA is found on that rolled up white t-shirt next to it. Greater than 700 billion. The analyst says we stop at 700 billion because we can't comprehend numbers bigger than that. Can you imagine if you were told you had greater than a 700 billion chance win the lotto? It was over 700 billion times more likely that you were going to win when you purchased that ticket than lose? Would you have an abiding conviction to go out and buy that ticket? Would you think you could lose? Well, I suggest to you that this piece of evidence is a loss for King Rollins. Because it's over 700 billion times more likely that that's his DNA on that shirt next to his prints on that gun from this stolen Nissan Altima that was just used to leave the scene of the murder. States 88, that same shirt, rolled up, balled up, and it's a size large. It's 89. You have the shirts, you can look at them. The one in the back's a medium, where Leroy Whitaker was, a little bit smaller. Also, states 92, you see a rifle in the floorboard, and then that white shirt, that medium-sized shirt, with Leroy Whitaker's DNA. Again, greater than 700 billion. I want to talk for a moment about the firearms. All right, you got the Glock. You already saw where the fingerprint was on it. And that gun, Dominique Varner says is his. Serves him no purpose in the world.
But they forgot to mention that the gun that his fingerprint is on, the gun his fingerprint was on was not used in the crime. It was in the car, but it was not the murder weapon. So why are they so pressed on that anyway? Where's the murder weapon at?
World to admit that gun's his. He's just feeding the story. Why say that's his gun? How does that help? Does it serve any purpose? No. But yet he's admitting that not only was he involved, but yeah, that was my gun. And he's just telling a story based on what he knows in discovery. He knows Hakeem Robinson's prints on it. Why not say that was Hakeem Robinson's gun? That's the prints on it. But he doesn't. He says, that was my gun. He admits it. And again, you don't have to like Dominique Varner. I'm not saying he's a good person. He's a criminal. He's just their kind of friend. And if you're going to plan a murder, who do you take with you? Is it not a Dominique Varner? You want someone you can count on. Their friend. Someone who shares the same goal. Stage 92, again, is that rifle. What I really want to point out, Stage 103. Because Dominique Varner says that rifle is Leroy Whitaker's. And it's in the back seat next to the item with Leroy Whitaker's DNA. And he didn't pull the trigger, Leroy Whitaker, but he's a principal. He knew what was going to happen, and he wanted it to happen. And this rifle tells you that without speaking a word. Look at it. It's an assault rifle. Okay? It's set to fire. That tab, set to fire, tells you everything about the intent for that weapon is to be used. Not only is it set to fire, there is a live .223 caliber round chamber. One small muscle contraction of the finger away from discharge. Stage 104, that live round. Leroy Whitaker's live round. Leroy Whitaker's intent. If that one wasn't enough, 107, 26 total rounds. 26 individual statements of intent. Leroy Whitaker didn't have to say a word in that Nissan Altima. And he killed him. You show up with a loaded AR-15 and chamber a round, set it to fire. You don't have to vocalize anything. Your actions have made it more than clear you're in agreement with what's about to happen. And if he didn't know what was about to happen, why is he bringing a rifle? Because they were on a hunt. So you bring the tools of the trade. 1214 Timber Lane, page 189. Leroy Whitaker, Dominique Varner. Right after they have fled the murder, Hakeem Robinson's gone west, they go east. And they leave their guns behind. Leroy Whitaker, not just a spectator, he's an active participant. He wasn't. He was roped into all this, had no idea what was going to take place, no idea what was about to happen, didn't want it to happen, stayed in the car. He could have got out, laid down in the front yard, put his face down, spread his hands, because officers were coming, and said, "Officer, officer." But he didn't. Consciousness of guilt. They're getting out of there. Left the guns behind, left the DNA behind, left the fingerprints behind, and then Dominique Varner and Leroy Whitaker are not leaving anything else behind. They're getting out of there. And from that moment, where do they go? 1033 Townsend Boulevard, where Dominique Varner and Leroy Whitaker both collectively committing burglary and assault or battery. To commit a burglary, to prove that, the state has to prove, in this case, because again, Varner already pled to it, admitted to it, to what he did. But Leroy Whitaker did the exact same thing. You have to prove Leroy Whitaker entered a dwelling, Buckley's home, and at the time of entering it, he had the intent to commit an offense therein, other than burglary or trespass. It's not like Leroy Whitaker was homeless, and it was 30 degrees outside, and he needed a warm place to sleep, and he thought this was an abandoned home, nobody's home, and I'm going to sneak in, commit trespass so I can sleep, protect myself from the elements. That is not what happened. He was protecting himself, but not from 30-degree weather or rain. He was protecting himself from the police. The police who were on his trail, trying to find him, trying to find Keem Robinson, and so, just like Dominique Varner, who behind the wheel was fleeing at a high rate of speed to escape, this is just a continuation of that, on foot. And so, with the intent to thwart the police, to escape the police, to resist the police, to ignore their orders, to stop, Leroy Whitaker and Dominique Varner both entered the home of Barbara Buckley without permission and with the intent to hide from the police, and that is a burglary, plain and simple. But they went a step further. There's an assault or battery. There also, I believe, here from the judge that you can infer that there was an intent to commit a crime inside that dwelling if it was done stealthily and without the consent of the owner. What did Barbara Buckley tell you? She didn't invite him in. She didn't even know they had entered. That's stealthy. She thought her cat shut the door to the bedroom. States 114, the enclosed patio that Dominique Varner and Leroy Whitaker entered as the police were closing in, and then in States 115, the back sliding glass door to the home, and then once inside, States 125, that bedroom to the front of the house, door open, and when that door got opened by Miss Buckley, looking back at her from States 126 in that closet, Dominique Varner and Leroy Whitaker. Two people she didn't know, had never met, had never been in contact with. Then the assault and battery by both Dominique Varner and Leroy Whitaker. Both, not just one, both. So if you find Leroy Whitaker guilty of burglary, you have to determine, was an assault or a battery committed? An assault is simply an intentional and unlawful threat by word or act to do violence, when they have the inherent ability to carry out that threat. So for
What up, Outlaw Nation, Native American? Listening to this is making my diabetes flare up. Yeah, we don't want that, family. No.
example,
Appreciate you joining.
when Miss Buckley is thrown down and
You
drowned,
almost done.
she's cowering on the floor, and Leroy Whitaker asks Dominique Varner, "You want me to hurt her?" That's an assault. And that comes after the battery. The battery is just an actual and intentional touching or striking another person against their will. That happened to Miss Buckley in 2019. Abdul Robinson Jr., Hakeem's brother, gets attacked.
Let me skip past a little bit because he is kind of on some bug. Just a little bit, not the whole thing. Get to the document parts.
That nature preserve, page 248, where Miss Gant took then Detective Smith to that apartment complex and said, "This is where I think Keem Robinson out." The defense would like you to believe that.
Then they want to play with the audio.
What to say?
Oh, he's still setting up.
Miss account, and if it does,
Looked like he didn't say nothing else anyway. I'm glad you said something. Good catch, because we was probably about to be sitting there.
and again, with
We can
regard
get to
to
the next lady. we could get to the cross, cause yeah, we pretty much heard everything he has to say. Appreciate y'all being here again. Once again, y'all hit the like, hit the subscribe button, tap in, share with a friend. Let's switch on over to the next one. Even though TSC been saying for a while, like, yo, this dude.
Isn't this a nice surprise?
At least make it interesting, jeez. He trying to think and talk. All right, here we go.
That we stand every time you enter this court. We do that with respect. This courtroom is literally majestic. At the great state of Florida behind your honor, we're on this road. We have two flags. The state of Florida flag and the state. And I point that out to you, ladies and gentlemen, because you have sacrificed. You have sacrificed your time. Time away from your family. Time away from your jobs. Time away from your pursuits. To be to sing. When we're in this hall, when we're here,
She's just walking further and further away from the mic. Like, she must know her closing was kind of garbage too.
We're not in some kind of chat room where everyone's spouting their opinions. Your own interest. As to each material allegation in the indictment or believed out, a reasonable doubt, the defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving, and the state always carries that burden, of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. And they go out of their way to define it whenever the words reasonable doubt are used. And this is what I want you to pay attention to. You always hear, and it's common because it is within the law, prosecutors say a reasonable doubt, and we even have a slide of a state's presentation. Reasonable doubt is not possible, speculative, imaginary, or forced doubt. That statement is an accurate statement of the law. If you add the rest of the sentence, and the rest of the sentence is, ladies and gentlemen, if and only if you have what's called an abiding conviction of guilt. One which does not waver or vacillate. Because if it does, even if you have a conviction, but it's not stable, it's one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt. And you must find the defendant not guilty because that doubt, which could be imaginary, forced, speculative, it's reasonable because you don't have that abiding conviction of guilt. An image I imagine most of us. What do people see when they look at this image? Do they see two faces? Do they see two eyes? When you have equal explanations, is it a vase beyond a reasonable doubt? Is it a fake two faces beyond a reasonable doubt? Ultimately, never let you forget this image as you think about the state's obligation. Because I want to talk to you about what their actual evidence was. And we heard, and I will tell you at the outset, probably should have started with this. You all not making a determination in regards to Mr. King. Not asking that. There was an argument too on that. Evidence is presented to you.
They obviously didn't plan this out very well. They should have gave her a lapel mic or something.
So let's talk about what evidence actually applies. Leroy Whitaker and worthy of your consideration. And I would suggest to you are basically kind of four categories of what we heard that had any application in regards to Leroy Whitaker. We have DNA records. We have cell phone records. We have Abdul Robinson Sr., a.k.a. Blue, and we have Dominique Barner. Let's kind of start with some of the most straightforward evidence. And I will say it's straightforward. The DNA evidence. Now you've got to consider what that tells you, what that helps you to determine. And we have two different kinds of DNA evidence. DNA evidence that was found in the car, and we have DNA evidence that's alleged to have been found in the property. Now, the DNA analyst, if you will remember, was very, very clear. DNA is transferred.
That might be on purpose. She might be trying to avoid y'all hear her talking about the DNA evidence.
You might remember the example of I can hold an object, give that object to another person. They have it, and they place it somewhere I've never been. It doesn't tell us when DNA is left. It tells us how. You've heard this statistical significance that she gives 700 words. But remember where that number actually comes from. It comes from the database. They actually created a database with, if you remember the number, 1,197 people have had their DNA analyzed and put in this database. They use that to determine, well, out of these 1,197 people, only 2% of those people had a certain DNA characteristic. And then they try to extrapolate that. Okay, the rest of the world must be like that too. And that's what I said. You keep saying no two people have the same DNA. That we know. Ultimately, you all decide, no, I think the DNA evidence is pretty compelling. What?
But every other mic works super clear. You can hear pens clicking, coughs in the background, the keyboard.
At best, if you wanted to believe every word, state scientists, in this case, from the Florida Department of Law Enforcement, their whole job is to aid law enforcement. If you even wanted to believe every single word, what does it at best? That Leroy Whitaker was in a car? That Leroy Whitaker does not tell us anything. Then we have cell phone records. And ladies and gentlemen, it sure seemed like we spent a lot of time establishing IP addresses. IP addresses, who called who. Did we have that kind of testimony? In regards to this alleged phone used by Leroy Whitaker, these population centers, we saw from all the photographs how many people are out at that Merrill Road. And these phone records, plus the exact location. Let's assume for a second you was chose to stop as a group. The phone records are awful. We think the phone records tell us where Leroy Whitaker's phone might have been traveling. Let's say we further even decide, you know what? I think that evidence was pretty compelling. I think it shows that he was at Merrill Road, and he was at Townsend Road, and he was at Over's house. Does that make him guilty of first-degree murder? No. Then we have Mr. Abdul Robinson. Mr. Abdul Robinson Sr., and we know he's a cooperator, just like John Warner. He's done it before successfully. So when he comes in and he takes it. And what does he say? He says, I had a certain phone number, and I got some calls that day. One was from my son, Abdul Jr., one was from Leroy Whitaker. Somebody I know because he is the big one. And I figure, I don't know anything else. Ultimately, I decide I'm going to go for my first. Right? Did you articulate to you all any evidence that Leroy Whitaker known about, thought about, participated in? Did you hear any evidence of Abdul Robinson Sr. saying anything close to that? I submit you did not. I certainly didn't hear it. I heard Abdul Robinson Sr. take the stand and claim, I picked him up. I had no idea what was going on. And then I took clothes and I run. But I asked him, did you ever hear Leroy Whitaker express a desire for anything to happen to Charles McCormick? Did you ever hear Leroy Whitaker say anything about wanting to do this, or going to do this, or encouraging anybody to do this? Not one word. So he doesn't give us anything. So what do we have? We have something on. And State Board just got at the very end of their argument, and they told you, hey, listen, we don't need these guys to prove this case. Take them out. If you don't have Dominique Farmer, if you can't trust what Dominique Farmer said, you have no principle in murder. Because he is the one and only person who claims Leroy Whitaker was a full participant. And I asked you in the opening statement, I hope you write down in your notebook.
So this is her and her client right here. I got this clip too. I don't know what's going on with the stream again, but this is her a while ago. Give a little break from that sound issue.
All right, Mr. Whitaker is present for pretrial conference.
Yes, Your Honor. Good morning. Julie Schlacks appearing on behalf of Leroy Whitaker, who stands to my left. Your Honor, much as the prior co-defendants articulated to the court, we were able to accomplish, again, more questioning of Mr. Barner, but more needs to take place. We do have that prior.
Mr. Whitaker is present for pretrial conference.
Yes, Your Honor. Good morning. Julie Schlacks appearing on behalf of Leroy Whitaker, who stands to my left. Your Honor, much as the prior co-defendants articulated to the court, we were able to accomplish, again, more questioning of Mr. Barner, but more needs to take place. We do have that set up for I believe it's the 17th. And so the 22nd is fine with my schedule, Your Honor.
All right, then we will pass Mr. Whitaker's two cases to May 22 for his next pretrial conference.
And Your Honor, I know that I had approached at the last court date and mentioned the concern in regards to my personal schedule. That is no longer a difficulty.
Oh, okay. We are.
Evidence that Leroy Whitaker, I submit to you, the only thing that's probably on your notepad is Johnny Clark. Because we just heard, and we heard from Detective Smith, that this right here, and ladies and gentlemen, you notice I did have Officer clear it because I knew I was going to pick it up. I don't want y'all to be nervous about it. But this
What up, Rock Solid TV? I see you, family. Appreciate you.
Now, this was examined forensically, if you'll remember. No fingerprints on this gun. No DNA on this gun. The only evidence you have before you that this is supposedly Leroy Whitaker's gun is John Lee Clark. And what's the problem with that, right? What's the problem with that? Number one, folks, it has been 5 years since this homicide. And Detective Smith took this man and he kind of quipped at me and said, well, he brought a loaded gun. I think that's pretty much a principle. See? Is there credible evidence? Are you waving and vacillating on whether or not that's Leroy Whitaker's gun? Because the only evidence that's been presented to you that that's Leroy Whitaker's gun is from a two-time murderer cooperator who has testified. He testified to us that he has testified falsely in the past. I mean, here is a man that came in and said in no uncertain terms, I've been involved in 2 murders. Yeah, I'm not guilty. Yeah, I'm testifying against everyone I know. Why? Because I want to get out of jail. I want to get out of jail. That's why I'm doing it. That's why I'm coming forward, is to help me. And what else did he tell me? One day, raised his right hand in a criminal setting. And I'm going to swear to tell the truth, the whole truth, and nothing but the truth. This knowingly lied. And he knowingly lied for his own personal purpose. He told
The truth is that you are a liar.
he wanted the person to get out of jail so he could kill him. He wanted to handle business himself. So he literally used our criminal justice system for his own personal aim. Openly commits perjury. Tells us all about it. And that's the evidence they want to use. Of the most serious charge you could
Wait a minute. Did she say this Mac Daddy gun? She said they flaunting the Mac Daddy gun? What is a Mac Daddy gun? Somebody please, hold on. Please let me know what is a Mac Daddy gun. I have never heard of that. Let me just hear that one more time. Make sure I'm not tripping.
We don't have some video of him flashing around. We don't have anything. We don't think there aren't 50 photos of him with this gun? This Mac Daddy gun? He's not putting out a picture of himself with it? We don't have some video of him flashing around? We don't have...
Look, I heard her say Mac Daddy, but I didn't know she said gun, though. I heard the Mac Daddy part, and I was laughing, but I didn't catch the gun part because I was already laughing. She said Mac Daddy gun.
Detective Smith, 5 years, and that's the piece of evidence. All guns have serial numbers. Detective Smith ever tried to trace this gun? It didn't just magically appear. There's all these bullets. They're huge. Was a search warrant ever conducted on Leroy Whitaker's house? Or he asked Detective Smith that? The interviews of his family. Surely somebody has seen Leroy Whitaker with this gun. This isn't just some handgun. This isn't some just revolver in the back of your pants. This is a Mac Daddy assault rifle. And if you're
Oh, Mac Daddy assault rifle. Mac Daddy, I guess it's Chonty. What up, adventuring? I see you.
the kind of person that uses instruments like that to gun people down, you're damn proud of them. And of course you know. No. You have the claim of Dominique Armour. Oh yeah, that's what you said. I imagine you might hear an argument. Well, we think there's 3 people in the car. There were 3 guns. Who testified to that? Even Dominic Carter himself. He said, I know I had this, and Leroy had that other gun. Shooter had some other gun. We know supposedly the shooter left with his gun. But just because there's an extra gun in the car, it automatically, logically, beyond a reasonable doubt, is Leroy Whitaker? Without any other evidence? Think about all the things Detective Smith could have, but didn't, or maybe did, and just the evidence isn't available, for this rifle. Because we know there's no fingerprints. We know there's no DNA on it. We know there was no search warrant for his home, any interviews of his home. We know he didn't attempt to trace this gun in any kind of way. And most importantly, you know the biggest thing you didn't have? This might have been a little helpful. You didn't have an iCloud or a phone from Dominic Barr. It is important to be known.
Look, she made sure she came back to the mic to say that part. She came to the mic and real loud. We know there's no fingerprints, there's no DNA, and then go back and drift back off into space. What up, late night baking with Mookie? Mookie, I see you, family. Appreciate you joining.
Remember how and why Detective Smith explained that. Why didn't you get an iCloud for Dominic Barker? Why didn't you try to get the physical phone by August of 2020? He's a state witness. He's a cooperator. You have, with acknowledging his lawyer, access to him. He wants to please you. He is trying to
Should be hitting them high notes though, huh? Cause he said. I was wondering about that too, cause you know how they all keep on saying that kill a nigga get my toes done line, and everybody keep talking about that. Why haven't nobody showed any of that? Like nobody showed a screenshot or a clip of it or nothing. Like we know it's in the song, but where's the screenshot of it happening that day? Like where's the stuff? Or did I miss that part? I watched the interview. Hey, for those who missed earlier, she was just talking about his family, so I had to pull up the brother. You know, the dad that was testifying, Abdul Robinson Sr. This is the son right here, Abdul Robinson Jr. I give a little taste, but I played this earlier in the live earlier today.
Apartments. Bro made it right. The police made it right. He sped up, hit his lights. Bro, the police behind us. Pull over. We straight. You know what I'm saying? Oh, nah, bro, I can't pull over, bro. I got the car from the south, bro. I got the car from the south. I said, bro, what you mean? The car stolen? He was like, yeah, like, you know, I asked him, I said, you stole the car. He was like, nah, bro, I got the car from some jits. I bought it, but it's stolen.
So he said he bought it. Okay. All right, good enough. Yeah, like I said, man, that shit was stolen. Now, police get behind you, you pull over and shit. When that point, when y'all pull over, what did you do?
I went in.
Why'd you run?
Because I was scared. Listen, point blank period, bro. I didn't want to go through this, bro. This is not where I wanted to be, dog. Like,
okay. So you took your chances of running.
And then you know what the lady
done with the shit, basically.
And you know what the lady told me? The lady said, bro, if you would have just sat in the back seat and waited, but you know, dealing with the police, like, and not. It's a crime. It's a crime we commit. And then not only did we commit a crime, but we ran, bro. You know what I'm saying? And then it's a gun in the car.
So you took your
like,
chance with
I'm
the
not
money and
finna.
then
Hell
get
yeah.
away with the
I'd
bullshit.
rather just be like, bro, fuck it, bro. If I just run, get away, fuck that. I don't gotta deal with that nigga no more. Molly out and put it on the scale. I put cracking shit on him.
Did you see him?
Nah, just when he broke, he had broke a piece of the Molly out and put it on the scale. I popped it up.
Okay, so he broke off some Molly and put it on the scale. Okay.
Just a little taste. That's his brother right there, Abdul Robinson Jr.
Let's remember what the evidence was. The evidence from Dominic Barnard himself, and the only evidence you were presented, is to support a theory of guilt for first-degree murder. For phrases such as, we all knew what time of day it is. I've never heard anything directly actually prove. To be a principal, it is far more. Number one, these are things that must be proven on to exclusion. Meaning, not wavering, not vacillating, finding conviction. And that's where it comes down to. The only evidence you received of these two elements was Dominique. And at the best of Dominique Garner's testimony, it was, I assume there must have been other conversations he brought supposedly alone. That, ladies and gentlemen, is not proof beyond a reasonable doubt of the defendant had a conscious intent that the criminal act be done, and the defendant did some act or said some word which was intended to, and which did incite, cause, encourage, assist, or advise the other person or persons.
All right, well, while she drifting off into space again, let's take a break and hear from her client. He is probably the only one I think that didn't snitch and was like, nah, I ain't saying nothing. So let's get a little bit of preview of her client that she talking about right now, Scotty. This is his interrogation.
Yes, because if you're wearing a mask, it's harder for the cameras to pick up if you're... What's up, Scotty? I had a question for you. What's up with that orange jumpsuit? I thought you were wearing green last time. Did you get moved or something? What floor are you on? You don't know what floor you're on? I don't know what floor you are. All I do is call and say, hey, I need this person pulled down. And they just tell me, they don't tell me where you are. Alright, no worries, you can tell me. Like I introduced myself earlier, I'm Detective Smith of the Jacksonville Sheriff's Office. We met before. You're at 501 Space Street, also known as Police Memorial Building. I got some things I want to talk to you about, but before I can do that, because where you are, I have to advise you of your rights, alright? So I'm just going to go over each one and just ask you if you understand it, and I just need you to say yes, because if you're wearing a mask, it's harder for the cameras to pick up if you're shaking your head yes or no, okay? Mm-hmm. Alright, you don't have to make a statement or say anything, do you understand?
Yeah. Can you do me a favor and just say yes or no, because it's hard for me to hear with that mask on. I apologize. And you don't have to take it off unless you want to.
Sorry. Alright, I'm going to start over. You have the following rights under the United States Constitution. You don't have to make a statement or say anything. Do you understand?
Yes.
Anything you say can be used against you in court. Do you understand?
Yes.
You have the right to talk to a lawyer for advice before you make a statement, before any questions are asked of you, and have a lawyer with you during any questioning. Do you understand?
Yeah.
Is that yes? Sorry.
Yes.
Okay. If you cannot afford to hire a lawyer, one will be appointed for you for any questioning if you wish. Do you understand?
Yeah.
And if you do answer questions, you have the right to stop answering questions at any time and consult the lawyer. Do you understand?
Yeah.
And I'm not saying this to insult you or any way. We have to ask. You can read and write.
Yeah.
Yeah, okay. You can read and write? Okay. Alright. If you can do me a favor and just sign this, all it's saying is that you understand your rights as I've read them on paper. That's all it's saying.
Oh, God, sign it.
You don't have to if you don't want to. Okay. You want to sign it? Alright, that's fine. Alright. Been a long couple months, sorry. Seriously, how's the jail been? I know it's been crazy with all COVID stuff. Like, have you been on any of those floors? You good?
I'm good.
Alright. So, did you happen to see anybody you know recently over that jail?
No.
Like, seriously, where before were you?
On the 6th one.
Okay, on the 6th. So the reason I brought you back over here is from like last time I talked to you, we talked about, sorry, give me one second. We're talking about stuff from January. Basically, it's come to our attention that you may be more involved in something than we previously knew. So I just got to get your side of the story because I got evidence that's telling me one thing, I got witnesses that are telling me one thing, and I also got other additional stuff that's telling me one thing, and I also got video that's telling me one thing. So this is your best time to tell me your side of the story about January and what happened, and I'm just trying to give you the opportunity.
He told him this your best time. This your best time to tell me what's going on. Hey, that's fucked up. Hey, it's only a couple more minutes of this. It's only like a minute and a half left. Maybe less.
You don't know, or? You ever been in a gray Nissan before?
He said, I don't know what you talking about.
You never been in a gray Nissan? Like a small, like, silver-looking sedan? Do you remember that phone number you had back in January? Leroy. Do you remember what phone you had back in January?
Daddy, I like when you scrambling and scraping for shit. I like that.
I'll put it to you this way. You keep going down this route when I'm just trying to give you your time to explain your side. You're gonna end up doing some time for somebody else when it was kind of clear that you might be the least involved in all of this, but still you were there. So, like I said, this is your time to tell me your side of things.
So I need no lawyer.
Alright, you want a lawyer? That's fine. Before I walk out of the room, I do have to tell you, you're being arrested for murder. We talked to Blue and KSOO yesterday, and they're next door, so. Give me a couple minutes, I gotta do paperwork.
Daddy, I like when you scrambling and scraping for shit. I like that.
Only one stays solid, and they about to hang that boy out to dry. You see how hard it is for them to get any information when you don't say nothing? Like, if you don't say nothing, how the heck is they gonna know what happened?
And again, think about what your testimony was. And what you might expect if someone was an actual participant. If someone was actually encouraging someone. Is there any testimony? Hey, Leroy Whitaker brought everyone ammunition. Leroy Whitaker stole the car. Leroy Whitaker yelled out encouragement. Go get it. Do it. Nothing. What does Dominic Barnum claim Leroy Whitaker did? The one and only thing that he claims. And I submit to you, even if we wanted to believe that, that would still be insufficient for a principal. Because what would bringing a gun do to incite somebody else? I mean, according to Dominic Barnum, he didn't need any incitement. He's up at 3 o'clock in the morning driving out to McCormick's house with his best friend, Chris Brown, to stalk him out and plan it out. And remember, it was interesting. I asked Mr. Barnum, I said, well, you certainly remember the details. You and your best friend, Chris Brown, driving out there that morning, talking all about the details, how you wanted to do it. All those details. Brown, never arrested. Oregon Williams. Even though, according to Dominic Barr, they should have. He could supply testimony. He could tell a jury all about Chris Brown's involvement. Chris Brown is with them after looking up core.
Hey, how many of y'all was here earlier when we showed the cop try to plant that crack pipe on Butter Girlfriend? I will bring that up later. The Butter Girlfriend, when the cop tried to plant the crack pipe. I just want to know, so I'll play it, but I don't want to just be redundant if most of y'all already saw it.
With them as they're going out to the apartment complex. Chris Brown evidently wants to be involved in this so much. According to Warner, he comes back out there. They talk go. Morgan Williams is allegedly arranging rides and going out there. The difficulty was, besides Don Barr, no, that's not even probable cause. Now, fast forward, Dominic Barner, in regards to legal liberty. Now, Dominic Barner can be believed, right? Because they have some corroboration. Any corroboration to Dominic Barner's claim that Leroy Whitaker had a conscious intent that the criminal act be done, and that he did some act or said something that's only who was it that stole son and how? Because we had no testimony. The other thing that I will tell you is probably the most telling. From the Jacksonville Sheriff's Office. We heard a little bit about it yesterday. Is that as an investigative technique, Jacksonville Sheriff's Office can do something that's called surreptitious taking. Look at how two suspects. And they'll do this oftentimes when two people are arrested together. They might put them in the back of a police car, put them on the camera. Same with the interview rooms. Put them in there. And you heard the timeline, and the timeline is somewhat critical. August 27, 2020, Dominic Barner agrees to be a state witness, files a sworn statement. All of the arrest warrants are completed at that point. Jacksonville Sheriff's Office didn't charge Leroy Whitaker with murder until Dominic Barner said the magic words. But then you have them, right? You've got those magic words. Dominic Barner is now at your disposal. He wants to do anything. They put Dominic Barner and Leroy Whitaker into a room and turn a tape on. They could have. You heard from Mr. Barner, who's right next door to Duval County Jail. Why wouldn't they want to do absence of that evidence? Are you wavering? Are you...
All right, here I'll play it. It's only like a 2-minute clip. It's the end of the at the end of the interview. He came in the room. This is immediately after she left the room. But I got the other stuff. I could play some of her in the room talking earlier. They was just asking her, can they search her house so they could find those red shoes and clothes that he had on when they did the homicide. But yeah, this is right after that. He come in the room. Look at this. Look how suspect he look. Come in there looking at the floor. And then look, act like he looking at the certain parts of the floor, but then he go to the specific spot though. Watch.
Do you want more sweet for the room? Okay. look and see if she had any weird credit cards.
I haven't gone through it.
Do you have any credit cards that aren't yours?
There's a crack pipe in the corner.
What's that?
There's a crack pipe in the corner.
She lying. That ain't mine. Do crack. No, that ain't mine. They searched me before I came here.
What'd you say?
They searched me before I came here. I ain't had nothing. You talking about crack pipe.
Oh, you put all your money right back in here. I'm making sure you don't have anything to get. You know.
Hey, how much money is that?
I'll get you. Yeah, flip-flops.
Then he gonna leave it there and tell the other dude, "Hey, can you go get that? I'm about to go to my car."
I'll be at my car.
Wait,
they're right here. Yeah.
Oh, I thought you said.
What's that? Yep. MC right there. Yeah, you can sit down. This isn't her stuff, is it? What the fuck is this? Huh?
There's a crack pipe in the corner.
There's a crack pipe in the corner. That dude, no, he was like, no, it ain't gonna be. And then, if you watch the whole interrogation, I mean, it show her from when they first walk into the room all the way up until they leave the room. She never even looked damn at that corner. She don't even look behind her or none of that. Like, she don't reach behind her. She's sitting at the table wrapped in a blanket. Let me move this thing right here. All right. There's a crack pipe in the corner.
Vacillating. You don't get to the other side.
Crack pipe in the base of the floorboards.
Another technique they could have attempted, and we heard, they evidently thought well of it because someone wore a wire on Dominique Barner. Why not on Leroy Whitaker? Why not? We're about to charge a 19-year-old young man with first-degree murder that you've heard from Dominique Barner. He had to make sure that he cooperated. He did not want to go for mandatory life. He has to say something.
Adventurous, he forgot the crack. He had to go back to get the crack. Hey, nah.
So it becomes Leroy Whitaker was involved. He was all in. I can't give you any details. I can't point to a text message. We just saw some text messages between evidently Abdul Jr. and Dominique Barner. Was Leroy Whitaker copied on that? Do we have text messages from Leroy Whitaker and Dominique Barner or anyone even mentioning Charles McCormick's name? Do we have any kind of posts that Leroy Whitaker acknowledges ATK, acknowledges 6 Block, acknowledges some kind of rivalry? No, we've only heard they have a rivalry. They were upset about Willie Addison's death. What has been shown to you about Leroy Whitaker? Ladies and gentlemen, I submit to you nothing. We have magic words from Dominique Barner, not supported by a single other piece of evidence. I want to skip to this slide because it is an important instruction in that the framers that actually set out these instructions, and they spent a lot of time doing it, they actually put this in the law because it's that important, because they recognize that you must consider the testimony of some witnesses, snitches, with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity or hopes to gain more favorable treatment in his case may have a reason to make a false statement in order to strike a good bargain with the state. May. As kind of an aside, because I know you guys have been here long, I'm going to tell you about my husband's and mine's first date. Because strangely enough, our first date was to see the movie Indecent Proposal. I don't know if you ever saw that movie. It was with Robert Redford, Demi Moore, and essentially you had this married couple, and Robert Redford ends up propositioning them that if Demi Moore will have sexual intercourse with him, and I have to tell you, as a first date, it was kind of an amusing movie to watch. Prompted a lot of fun conversation afterwards. They were still married, so it all worked out. But I think about that kind of scenario in the scene.
Are you in the pre-com?
He's 31 years old. 20 years? We know, and we know it's much less than that. If he ends up getting 20, he's got 5 years credit. He doesn't have any more mandatories, so he ends up getting out even less. He's still in our community. Well, he has to do, oh, that's a long time to be. What would No, he told you when he did back in the day, he was able to get probation when he testified against his friend Mark Clayton. Said, absolutely, willing to do it. I'm ready to get out of jail. I'm gone. Anything. But he needs convictions. And he needs a lot of them. Because he's got 2 separate murders, he's got to atone for, he's got an aggravated fleeing, and he's got a burglary with assault or battery. Dominique Varner needs convictions. It's not going to be sufficient, not for his sentencing hearing that he has planned, just to say, oh, well, yeah, we went into the house. No, Leroy Whitaker needed to
Stay there now. Stay there. I demand you stay there in front of the mic.
be part of it.
Jeez.
He needed to be part of it so that Dominique Varner can have one more conviction to try to hang his hat on of why he should get out of jail. As he said, well, I think I should get the 20 years because I'm bringing justice for the family. And with that, you do have to recognize, and I mean this in all sincerity, homicide detectives work very, very hard. I'm confident of that. And I don't think Detective Smith is any stranger or anomaly of that. I'm sure he works extremely hard. But there is pressure on homicide detectives. Because as I asked him, they're the ones that have to go and sit down with the family to explain your loved one's not here. And so there is pressure to get anyone that was a part of the death of their child. That pressure is understandable, but it doesn't erase their obligation that they do actually have to prove it. It's not enough to simply say, he was in on it. I'm sure there were conversations. Because at the very end of the day, ladies and gentlemen, even if you wanted to try to believe Dominic Barner when he claims, well, once we got to the apartment complex, there was this discussion that both Leroy Whitaker and the shooter were going to shoot. Both were going to do it. What
Both. Both. My bad. I had to do it.
we know? Both Leroy Whitaker and the shooter were going to shoot. Both were going to do it. What do we know? We know Charles McCormick was killed by a lone gunman. So even if you believe every single thing the state has presented to you, the reality is he didn't do it. They've shown nothing, not through photographs, not through Instagram posts, not through phone calls, not through text messages, not even through Barner's testimony, any evidence that Leroy Whitaker had any intent for Charles McCormick to die. I am going to sit down in a few moments, and I ask you to indulge me for just a few moments while I go through my notes. Because let me tell you the worst thing for a trial lawyer, and it doesn't matter what side you're on. You sit down, and 2 seconds later, I'll think of something that I was dying to tell you that I just simply forgot. Another difficulty in terms of that lack of evidence, and reasonable doubt can come from it, there was zero investigation in regards to this car. And Detective Smith, again, was like, well, it had been gone for 2 months. But again, they're trying to ask you all to convict of the highest charge in the land on Dominique Barner's testimony alone. Nothing else they presented proves the principle or even alleges it. He didn't even have probable cause until Barner said those magic words. Why? Because being at the scene of a crime is not enough. You need to do more. And they've literally not shown you anything. But why wouldn't? Detective Smith, you have this car that's stolen. 2 months ago, did you even bother to talk to the person who owned the car? No. Did you even talk to the last person who drove it to understand how exactly it might have gotten stolen and if there's any potential leads for us to figure out where this car was for 2 months? No. Detective Smith, you have, as a Jacksonville Sheriff's Office tool at your disposal, these license plate readers, various spots in Jacksonville that you just type in the license plate and it will tell you, hey, on such and such day at such and such time, this car passed this intersection. Here's a photograph of it. Is anything done like that? Would that have been helpful? Ladies and gentlemen, I suggest it might, because we have a complete lack of evidence. The most simple thing, and if you think about the allegations are that all of this involves this.
Situation, but I know I'm the reason my dog died. They in the ground aging, and I do anything for KSOO. I went broke for his case, staring at my bank account.
Big drill music.
My bad. I had to cut that in real quick. I remember everybody was asking me, is it true that Young and Ace paid for his lawyers and paid for his case? Well, in his song right there, he just said, I went broke paying for his case. Or, you know what I'm saying? I went broke for his case. I do anything for KSOO, went broke for his case. So, I don't know what that say, if that answer y'all question, but that's what he said. It sound like. What you think? Let me see.
his case. Staring at my back, so I went broke for KSOO. I went broke for his case. Do anything for KSOO. I went broke for his case. And I do anything for KSOO. I went broke for his case. Staring at my bank account with a baby on the way.
Rap music. Ever turn the car on and figure out if anybody actually connected it? No, our software can't do that. How about just manually looking if there's a phone attached? Not done. That's a lack of evidence, ladies and gentlemen.
Nah. Hold on. Not for this lawyer. This not his lawyer. This is Shoddy lawyer. This Scotty lawyer, Shoddy. This Scotty lawyer. This not the one he allegedly paid for. But if it is one that he paid for that they talking about, it would be Tara. That's the other one, Tara. So she ain't did her closing yet. It's probably gonna be tomorrow. I'll probably be up tomorrow morning like 6 o'clock, maybe 6:30, 7 o'clock, streaming that in the morning. The closing of KSOO's lawyer, Tara.
We have no evidence of social.
It's the cases are being tried together, but it's actually like two separate trials. They separate jurors, separate juries and stuff. So this is just the closing for Scotty. Closing is tomorrow. KSOO closing is tomorrow.
Media posts of Leroy Whitaker, of rap lyrics of Leroy Whitaker, of notes in his phone of Leroy Whitaker, text messages bragging, none from Leroy Whitaker, text message to Leroy Whitaker, talking about McCormick, talking about being with them. None there. We have no evidence, besides Barner, that that's his gun. We don't have anything tying him to the gun. We have no investigation as to the serial number of where this gun came from, how it might have gotten into whoever's hands had it, how it got in that car. None of it. We just assume. It's almost as if Leroy Whitaker is almost a footnote, an afterthought. Oh yeah, and Leroy Whitaker. Oh yeah, he was all in. We don't have any actual evidence that he ever manifested any desire for Charles McCormick to die, that he ever did anything besides potentially sit in an Altima car. That's what they've shown you. Detective Smith told us all we ever asked from Dominique Barner was the truth. He didn't ask him anything. The last question that I asked Detective Smith, if you remember, because we had these questions about how even after arrest, the investigation continues. And on September 11th of 2020, Detective Smith had executed that arrest warrant that talks about phone records, that talks about DNA, and most importantly contains those magic words, because Dominique Barner has come forward. But if you remember, my last question to him was, after the arrest, number one, of Dominique Barner, did you, Detective Smith, ever sit down with him and say, okay, let's really talk about this. Let's make sure that there aren't any other investigative leads now that I have full access to you, like your phone or your iCloud or anything else. Never spoke to him. And
Rains graduation, man, that man had his chain packed.
I don't see my chain on at that graduation, man. Why niggas be lying, man? That shit is crazy, man. That shit.
The ops be lying, I swear to God.
I just let y'all know.
Let me tell y'all something. Them niggas made a whole.
Wait, that's his son in my hand, bro.
That nigga made a whole diss song. That nigga made a whole diss song about nigga smoke 23. Both of them niggas ain't killed 23. Like that shit wrong, but them niggas lying in their music. Them niggas say they smoking 2 times. Them niggas ain't killed him. Mookie was in jail. Them niggas was in jail, bro. Nigga was in jail. Nigga ain't killed nobody. They got no bodies, man. Nigga bad about shooting up a house. Nigga mama got shot the fuck up.
I asked him, after that arrest warrant, did you ever, I know your investigation supposedly continued, did you ever develop any other evidence for the theory of principle of Leroy Whitaker? And vacillate. Leroy Whitaker was involved in this homicide. Leroy Whitaker manifested some intent. We have no evidence of that. My greatest wish for you as jurors, after you ultimately leave our hall of justice, is that you feel pride about your experience, pride of being part of the system that we all do cherish, pride in a system that upholds the law and is bound by the law. And you all are bound by the law. The burden of proof in this case is beyond and to the exclusion of a reasonable doubt. And to illustrate just how high of a burden, really think that all of these things, if we were somewhere not in a hallowed hall of justice, and we thought to ourselves, you know what? 3 guns, 3 people, I think it's pretty logical that gun must have been his. We think, you know, their family, yeah, he probably did know what time of day it was. Those are all guilt, most likely. Legally, that's not guilty. Guilt, likely, not guilty. Probably guilty, not guilty. Possibly guilty, not guilty. Suspected, not guilty. Perhaps not guilty. May not be guilty, not guilty. Possibly not guilty, not guilty. Unlikely guilty, not guilty. Probably not guilty, not guilty. Less than likely guilt, not guilty. Not likely guilty, innocent. When the state falls short, ladies and gentlemen, your constitutional burden is to find him not guilty. On behalf of now we urge you to follow the law, analyze the evidence, Charles McCormick to that, nor do you do a single thing.
All right, thank you, Ms. Schlatt. State rebuttal close. Right, I think they said it was only to be made to regarding Raekwon Howard.
Their blood by Hakeem Robinson, Abdul.
So I won't allow you to make that particular argument as to Raekwon Howard. I think it's abundantly clear.
My bad, y'all. I'm looking for that part where she explained the jury real quick. But also, I'm loading up this picture because y'all was asking about the jury. Y'all was asking, was it 6? I think it's 6 and 6. It may be 12. I don't know, but I think it may be 6 and 6 because I only saw about 5. But I can show you. I can show you half a. I don't know if it's half or whole, but I can show you Hakeem's jury if y'all would like to see. I think it's open. Let me see. Is this it? Shit, I can't see it. Let me see.
Again, for this delay. Things come up. They have to be dealt with by the court outside your presence, and so we have done so, but I assure you the case will be moving along much quicker from this point forward. I do have to ask during this lunch recess if any of you read, watched, or listened to any newspaper stories or even saw anything on social media with reference to this case. If so, please raise your hand. All right, and I see no hands raised. Did anyone attempt to speak to you, approach you, say anything to you about this case or the people or places involved in this case? If so, please raise your hand. All right, and I see no hands raised. Thank you very much. All right, we're still in Defendant Hakeem Robinson's case. Mr. DeCoste, you may proceed.
Thank you, Your Honor. Defense offers into evidence what's been pre-marked as Defense 4. I can approach.
Okay, yes. All right, Defendants 4 will be accepted into evidence.
May I show it to the jury and go ahead?
Yes, you may. Okay, thank you.
Record before that paragraph.
Lessers are
Second degree and manslaughter. Calling of defense counsel or okay.
Just the highlight, not
just to highlight those 3 words in element number 2. Okay. When there are lesser included crimes or attempts, do you want to take away the word or attempts since that's not charged or focused here in the title?
no objection.
Senator, I think that attempted first degree murder should be part of it. Mandatory lesser included offense.
It's not mandatory.
Not attempted.
Yes, we asked for attempted.
Oh, you did ask for attempted?
We would.
Okay.
I did look these over. I honestly, that just went right over my head. But yes, I absolutely think that should be part of the instructions on the facts that are alleged by the state court.
All right, I'll hear from the state on that.
Your Honor, there's no evidence that this is an attempt. The victim was killed at the scene by the act that would constitute the attempt. I think it's.
Yeah.
I mean, I just don't. I'm looking. My understanding is that the only mandatory lessers are
Second degree and manslaughter.
second degree, which I've provided. We're going to look at it right now together.
Yes, it's not a category 1 mandatory lesser.
I would have to concede that it's not mandatory. In fact, I don't even see it as an option under category 2. Is there a second page, Alan?
Yes.
Okay, I will concede that it's.
Okay. So let's just remove those 2 words on the title of attempts or attempts. And so do you agree with second degree murder and manslaughter as the 2 lessers to be given?
Yes, Your Honor, I concede that I'm not entitled to that.
All right. And to the instruction itself, are you agreeable to that?
Yes, Your Honor.
Very good. All right. Then we have the instruction for second degree murder that's covered on 1 page. Any objection?
No objection as viewed right now. You can take the highlight out.
All right. So we'll take out or principle under element number 2. And with that edit, any objection?
We're taking out the highlight, not or principle. Important, so I don't think it's.
We have the standard plea of not guilty, reasonable doubt, burden of proof instruction. Any objection?
No, Your Honor.
Weighing the evidence instruction. Number 7 and 8 are duplicative. 7 should.
When they intentionally, knowingly, with.
All right. Anyway, let's get back to it. I was looking for that part. I'll find it on the side while we play the other prosecution. He a little bit more interested in the first one, even though he kind of go off the mic a little bit too. But we'll go ahead and play his while I get the next one loaded up.
Of pressure.
mean, I understand they trying to get close to the jury and impact the jury, but y'all got to plan for that ahead of time. You got to bring your lapel mics.
For the horrible crimes committed against them. And the defendant is not guilty because bad things happen to good people. You better believe that there's pressure. Because what the defense will have you believe is that these two crimes will go without justice, full justice, based on DNA evidence in multiple locations with a 700 billion times more likely ratio that is this defendant than anyone else in the world. And his phone records would put him every single step of the way exactly where he's supposed to be and totally corroborate what that other criminal said. If he ran from the scene and beat a woman to make sure he got hit. Innocent people don't run away and break into the houses of citizens on Townsend Boulevard because they're just along for the ride. We heard an hour closing argument from Ms. Schlax, and God bless her. She is upholding the defendant's right of counsel to zealously represent him within the bounds of the law, and she did that. And she spent 59 minutes and 30 seconds talking about Charles McCormick, and about 5 seconds talking about Barbara Buck. Why do you suppose that is? Why were these crimes charged together? And Ms. Schlax is right that you're to consider their verdicts separately. We considered all the evidence in the case. The evidence against Hakeem Robinson and the evidence against Leroy Whitaker for both charges together because you can't unwrap them. This is one criminal episode. And the evidence against Barbara Buckley 1,000% proves he was involved in the murder. Why else do you break into a woman's house and grab her and say, I'm going to hurt her? Why on earth do you do that?
The evidence is going to show that anything that I may have said, they exacerbated it.
And that's why it wasn't discussed. Because if you analyze this case in total, there is no reasonable doubt. She talked about the evidence is DNA. The evidence is cell phones. The evidence is blue, and the evidence is barter. She left out a really, really important thing. And that is your God-given common sense. Your ability as a human being to realize that 2 plus 2 equals 4. That you can make logical inferences from the evidence to speak to what the truth is.
Who's you talking about, Willis?
That you have judgment. And I'm going to go through a whole bunch of things that prove that Dominique Barter didn't lie. Because they lied.
Fucking nuts.
So first, I want to talk a little bit about the objective truths that have nothing to do with Dominique Barter or Abdul Robinson. The Addison family and ATK was dissed by the victim in 6 Block in a song making fun of their loved one. That limits the number of people in the world. Mr. Cooper is going to pull up proof. As Schlack said, there's no evidence that Scotty is involved in ATK. There is. The fact that his Instagram has ATK on it. Can you just circle that shit that I'm talking about? Life of ATK. The big ATK written. Huh. I know, listen. I can say Mr. Cooper far better individual ethics than I am, so it doesn't matter. We threw a lot of stuff at you, and I get it, these things are missed. I don't think your Slacks is trying to miss you. We're from the same generation. But it's in there. The testimony is uncontroverted. Ms. Robinson, who we heard from today, said, oh, they're not just friends, they're cousins. They're blood, man. We were all Mr. Whitaker is in for a penny, in for a pound, just on motive. That should not be a dispute. He is objective that he is part of that group. Now, is he as big as Hakeem Robinson? No. Is he a rapper? No. But he's with them. We see the pictures of them together. We see videos of them together. They are hanging out thick as thieves. So the number of people that were willing to kill Charles McCormick, who's showing up at an employment service, is limited. It doesn't mean it's Leroy Whitaker exclusively. No, it doesn't mean that. But it's limited. That's objective. Number two, that both defendants, and remember, the evidence against Robinson corroborates the evidence against Whitaker and vice versa. That's why we tried them together. And I agree with Ms. Schlax's point that the verdicts are separate. That's why we have two juries. But you have to consider all the evidence to see how all the evidence fits. Both the defendants had the opportunity. The whole point of the cell phone evidence, Ms. Schlax is right. It's not GPS. It doesn't put him everywhere at the exact possible location. What it doesn't do, it doesn't exculpate him. It doesn't show he's somewhere else. In fact, it shows he is everywhere that Dominique Barner says he is. Cell phones. Mr. Whitaker's cell phone stuff is actually the TDOA, the bands, and actually gives us a little bit more precise. And if you remember that testimony, he is at every location. He is at the Maryland Road, he is at Townsend Road, at both of them. Receiving calls, texting locations, all his phone. We prove it's his phone. We'll know this, not to do it again. The Instagram for the defendant, this Instagram was verified with this number. He has all these little selfie pictures. That's how we prove it's a selfie. And it's corroborated because it's going exactly what Dominique Barner says it's going. Again, this is objective. The selfie stuff is objective. It puts him in Townsend Road, and it puts him at the scene. And that stuff has nothing to do with Dominique Barner. Oh, and guess what? Robinson evidence does the same thing. It turns his phone off with his real phone, his burner phone. The data is hitting on all the points it's supposed to be hitting. Corroborating everything. Objective evidence. We know.
So they go through all that, cutting off their phones, putting on masks, hiding their face, covering it all up, and then they go and talk about it on the song and post a Instagram chat saying, kill a nigga and get my toes done. What was the point of wearing the mask? You might as well just let everybody know it was you from the jump.
Know that the Nissan car is the murder car. There is no dispute about that. The Nissan car that crashed is the murder car. That was trailed and followed by the police from the scene of the murder, from the dash cam, until it crashed on Townsend Boulevard, and people started running from it. Right? And we know that the shooter fled from the car with the weapon. The same weapon he used to kill, and it's Hakeem Robinson, there's no doubt about that. The same weapon he used to kill Charles McCormick is the same weapon somewhere in Tree Hill Preserve.
But you don't have the weapon, so you can't prove that. So how do we know if that's true or not?
The truth is that you are a liar.
What up, Miss DB? Indigo Kepera? What up, what up? I see y'all. Appreciate y'all joining, family.
The same weapon he had in that video that you can see, the video, Bang It Up video, is the same you can see. And that guy ran out with his gun. He's got to be murder. These guns are considered relevant, very important to the case. They're not murder. He took his murder weapon and got rid of it. And that is why Dominique Barner went and used his pistol. Because he's like, man, you're not using this. You got to throw this away. You can't even call it murder weapon. You can't have my gun. You got to use your own gun. Anyway. And so we know that there's two guns left. The murderer took the weapon, and we know that we found two guns in the car. Mr. Robinson was linked to the murder car in three ways. The shirt in the driver's area, his DNA in the driver's compartment, and the print on Dominique Barner's slide of his handgun. Three different ways he's placed in that car. Whitaker was placed in the car in two ways. Leroy Whitaker was on both shirts. One of them was with Hakeem Robinson. Both of these shirts, whether they were worn or not, maybe they were worn earlier, maybe they were worn as masks to cover, we don't know that exactly. But we know that they were kind of balled up, especially the one in the front, and wrapped up right next to the gun. They're wrapped up, and they both have their DNAs on them, 700 million times more likely. Okay? It doesn't just jump around. He doesn't just jump around. So, that two shirts puts Whitaker in the car.
So, jury of his peers, 50% say no, 37% say what is that, and 12% say yes. Is KSOO guilty? 61% say no, 15% say yes, And 23% say both of them, which is actually no, because that's reasonable doubt. Appreciate y'all for participating. Much love, much love. And shout out to our stream sponsors of the day. We almost up out of here. Appreciate y'all for the sponsorship.
The absence of evidence is not the evidence of absence.
What?
He's on the driver's side and the passenger in the rear part. And Schleck said over and over again, there's nothing that puts him on this, to this gun. Which was swallowed. Tested. Nothing was on it. That means no one's ever touched it. Of course not. And fingerprints are sometimes tough to get. If you touch something, it doesn't necessarily mean something behind. Almost, it's not on top of it. It shows in the seat. And the gun's right there on the floorboard. You can't sit in the back seat without touching the gun. You have to see it. And Leroy Whitaker's DNA is on that shirt. There's no real dispute about it. We hear a lot of dispute about that. His DNA is on the shirt. A lot of dispute about it. She screams over.
Adventurance said, whoever said yes, come to the front of the class. FFS said, who are the 12%? I need answers. I'll tell you this, the world will never know. I guarantee you, whoever it is, they will never come and say, yeah, that was me. Not that we going to attack them or nothing. They just, some of them don't even really believe it. They just click on it just to be vice versa of what everybody else going with. They just want to be the opposite. But we open to opinions. Y'all speak your mind. Y'all welcome here. Speak your mind.
Over and over again, there's no evidence. But if your DNA is on the shirt in the backseat, right, almost touching a huge rifle, that's pretty good evidence that that defendant had that gun. It's pretty good evidence if you use your God-given common sense. Robinson possessed a similar unique firearm before the crime. We talked about that. Now this is, I can't stress this enough. I opened with this. But Whitaker and Barner were so desperate to get away from this crime scene that they broke in to a woman they did not know, a 57-year-old woman's house, and they left their DNA on her pajamas. It wasn't just DNA. It was blood. It was blood on her pajamas. And the testimony from the DNA analyst was it was both a single source from the mixture. So you're gonna find
No one said trampoline action on that.
on his body and on her clothes. And if you're wearing clothes, you're going to find my DNA. She's looking for DNA foreign to the neck, the hands, and the clothes. She tests, or she thinks she can find DNA. Test all tests for blood. Barner's blood and Whitaker's blood. But it's not a mixture of the two of them. It's really, really, really. The blood that matches this defendant. Only his blood on her pajamas. That cannot be transferred. Because it would be Barner's mixture. It's his blood. How does his blood get on her pants? The only way. She described it. By the way, calling him the squirrely one, no offense. She described it. Squirrely one. Squirrely one participated in pulling me back and grabbing me. Squirrely one threatened to hurt me. Ask Barner if I should. Proof beyond the exclusion of every reasonable doubt. That's proof beyond all doubt. That's proof beyond a shadow of doubt. He committed a burglary with assault and battery. And what that means is using your God-given common sense that you're going to believe that he had nothing to do with the murder. When he's leaving his DNA next to the firearm? When they're sitting with him hours and hours leading up to all this? Whitaker and Barner got picked up by Blue. We have the pit track. We have the cells. Blue pled to do that. He said, I'll do Russell. I came out to pick these guys up and they got me on the hook for the accessory after the fact. These are undisputed facts. Robinson is right-handed, wore a black and gray hoodie just like the one the shooter has. Robinson was very happy about the murder and liked to brag about it. The video proves that the descriptions of the shooter were all wrong. So let's talk a little bit about motives to lie. All of that evidence, I submit to you, we don't need one at all. But we still have to analyze what he has to say compared to the known evidence. Is he telling the truth? He is a liar. Actually, he's being lying. Those are two very different questions. Very different questions. So, Barner, first of all, this is a minor point. Barner and all witnesses, every witness, met with the prosecutors and the defense attorneys before testifying. We heard a lot of questions like, well, how many times did you meet with the state? Yes, that's implying that somehow Mr. Cooper and I are telling these people what to say. We're doing a real crappy job. We meet with our witnesses because we need to know what they're going to testify to. And you know who says it's okay to meet with your witnesses? The law and Judge Salvador. Quote, you will hear this later. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Quote, Judge Salvador, when you're charged to hear this case. No witness should ever be discredited because they sat down and talked to both sides about what they would testify to if called as a witness. That is the law. So Dominique Barner shouldn't be discredited because he met. Dominique Barner, and this is a fact, Dominique Barner wants to get the best deal for himself. I don't think there's any doubt about that. He's doing this for selfish reasons. He's not doing this out of the goodness of his heart. He may say that. You know, I want justice. Okay, whatever. Talk a second about his deal. There is no evidence he's getting on zero. That is the minimum Judge Salvador can give him. And she can give him life without parole. Anything in between is her decision alone. This whole concept that we bought this testimony, that's a real bad deal. He just pled guilty, confessed over and over again under oath, 9 hours of deposition, confessed to multiple murders, and he knows that this judge can say, I appreciate what you did, Mr. Barner. I'm giving you life. That's the deal they're talking about? To strike a good bargain? What kind of bargain did you strike with the state? But his plan, according to the defense, his plan...
Hey, Adventuring, I wish you was on the mic because I would love to hear you say, what's that, in your Cardi B voice. I ain't gonna lie.
Is to lie. When we have that much leverage over him, Judge Salvador has life to hang over him. And he's going to go, you know what? I'm going to make up who did this with me. Just going to make it up. Leroy Whitaker had no idea what he was doing. Right? He was just sitting in the car. We tricked him. That's the argument. What if we find out evidence he was lying? After pled and looking at life. How would that look in his sentencing hearing? Your Honor, Mr. Barner agreed to testify and cooperate, but he lied about who was involved in this case. He said Mr. Whitaker was involved, and he wasn't. What? That's where you have to critically analyze what Barner's saying. Of course, he wants to make sure that the truth comes out because it'll help him. It'll help him because the evidence will corroborate the truth. All that pressure will get justice. Bullshit! Made up. Barner doesn't know that Blue's going to testify. Blue doesn't know Barner's going to testify. Well, maybe he did by the time he flipped. Barner didn't know Natalie Gay and Renata Boston were going to testify. Again, this relates more to Hakeem Robinson than it doesn't. He says Hakeem Robinson is the shooter. He doesn't know Renata Boston's going to come into this courtroom and Renata Boston will say, yeah, it was some dude, I got an alert on the phone, and some dude wearing a black and red jumpsuit came crawling out, walking out of the woods. And some white girl driving around looking to pick somebody up. And Natalie Gant, who is not, and some white girl was driving around looking to pick somebody up. And Natalie Gant crawling out, walking out of the woods. And some white girl was driving around looking to pick somebody up. And Natalie Gant, who is not, we have no leverage on her. None. Nobody's arrested. Nobody's in trouble. Natalie Gant, just take a sworn statement once we figure out who she is. Take a sworn statement. Yeah, I went and picked up Hakeem Robinson from the exact same location that his phone's pinging that we have that little map. That corroborates Barner. And that means he's telling you the truth about all this stuff. Barner didn't know that the digital expert Latham was going to do a body morphology and conclude the defendant could be the person behind the mask. Same argument. Has to do more with Hakeem Robinson. This means he's telling the truth. When he says it's Hakeem Robinson, he doesn't know that we're going to spend $70,000 on some digital expert to go, yeah, kind of sounds like him, kind of looks like him, it matches. It's consistent with it. Barner didn't know that we would be able to link Whitaker's phone through Instagram and prove everything that he testified to. Barner couldn't have known that the cloud would capture proof that Robinson's burner phone was his and would link Robinson to the murder. I mean, for all of Dominique Barner's issues, I don't think his brilliance is going to be argued by anyone here. So he's supposed to know all this stuff and predict it? Barner could not fabricate the DNA evidence. He could not fabricate the print evidence. That is overwhelming, and it proves this defendant's guilt. Barner didn't know that Robinson's known cell phone would be turned off during the murder, but his cell phone data from his the cell phone from the burner phone would be hitting off the towers. He also didn't know that the cell phone data from the known phone which we remember we did the Google searches for the plots. And the analysts said we don't do that because the data is 95 to 98% reliable, and that's not good enough for us, so we don't chart where the data is, because we know there's some anomalies, so we don't chart that. But the defense went up, put the numbers anyway. You know what that shows? It shows that the numbers...
Lady Justice is blind. Everybody can hear.
Picking them up and then driving to a Grand Boulevard with a pick up to Nissan Sentra. Then it magically turns back on when everyone's together and all the crime is over. That's interesting. How does Dominique Barner know that? So let's talk about the principal instruction, because we heard that over and over and over again. Mr. Powell's going to pull that up. So again, we're using your common sense. This is how we prove it's a principal on Charles McCormick. Right?
Where are your police reports?
Ask proof the unreasonable doubt, and that is really, I said to you, enough evidence to prove murder, because nobody does that to an innocent woman unless they're...
This time say what I did 10 there. Stacey did with 30 and into Yarn. This time say what I did 10 there.
But let's analyze it a little bit more. We know that they were all together for hours. This plot is all night. They're actually sitting in the apartment of Charles McCormick waiting for him. They didn't kill him. They were sitting there for hours. It was like a stakeout. Unfortunately, they're not as good as the police at doing stakeouts because they got distracted and they're playing with their phones or whatever it is. They miss McCormick leaving. But they're there for hours. Mind you, with all these guns, this rifle is not concealable. Raheem Robinson's pistol rifle is not concealable. They're all sitting there. Having a conscious intent of the act be done is like going to a football game, getting invited to a football game. Hey, we're going to a football game. You want to come? And it's driving all the way to the stadium, sitting there for 4 hours, shaking a pin in the air, watching the game, having come out. I didn't have a conscious intent to go to a football game. Because I didn't say I wanted to. I just sat there cheering. So, we all know they were together stalking the victim. We know that there's a huge rifle in the back seat.
But you just lied.
Could not have missed. Whitaker, and this is an interesting point. When the crash happens, Robinson goes his way.
Bruh.
Driver and Whitaker both go together. Whitaker is leading. Whitaker does everything from that point forward in terms of getting them away. He jumps over the fence first, presumably cutting his leg. And Barner's right there. And then they follow each other, Whitaker leading into Miss Buckley's home. He is leading the escape, leaving his blood unmistakably on her leg. Barbara Buckley's testimony proves to you on Dominique Barner, why are we in this woman's house? What just happened? Why did we shoot that poor man in broad daylight on Merrill Avenue? He's like, hey, you want me to hurt her? Brother? You want me to hurt her? Barbara Buckley doesn't hear a word of animosity, doesn't hear a word of fighting, doesn't hear any conflict between the two. And both of them working together and in conjunction proves what Dominique Barner says. It proves that the defendant is a principal. Because what's the common sense? I just witnessed a murder I had nothing to do with, and now I'm breaking into a woman's house to get away? Am I going to work with the person that was obviously in on it? Driver? No. No. They were picked up together, both wearing the Buckley pajamas, having both left their blood all over Miss Buckley. Working together as principals. And they all have the same motive.
The absence of evidence is not the evidence of absence.
What?
Big shout out to Allie coming through with the 5 spot. Appreciate you, family. Y'all show Allie some love. Drop her some coins in the chat. What up, what up, what up, Flesh of the Gods in chat. Finally free from them bushes. Appreciate you coming in and showing some love, showing some support. It's definitely greatly appreciated. Oh, I forgot to turn my mouth on. There we go. Turn my mouth on. Yeah. But it's definitely appreciated. Let me drop you a bomb real quick. And we get right back to it. Y'all show Allie some love. Drop her some coins. Stream sponsor of the day from the first stream and the second stream. Boom. Appreciate you, family. Much love, much love.
not the same motive. A couple of points about the DNA. The defense says, oh, it's flimsy, 700 billion. This is science. This is scientifically accepted in the community at large. This is what DNA evidence is and has been for decades. This is the statistical certainty that they can provide, which is much lower than the actual statistical. Remember, she said it's way more than 700 billion, but we only provide the 700 billion. If you try to count to 700 billion, it would take you 25,900 years to get to that number. You would count 1, 2, 3, without breaks.
And
never sleeping, never drinking, never eating, never dying. It would take you 25,900 years to get to 700 billion. There is no doubt that the blood is the defendant's. DNA on the shirts is the defendant's. There is no doubt. 3 people, 3 guns, couple of small points. The search warrant of the Whitaker home, he's arrested months later. Remember, we didn't arrest Whitaker for the burglary with assault or battery because we didn't have the DNA for months. Hakeem Robinson was developed as a suspect very early because of the DNA. We had those results. Get rid of phones. We don't have his phone. To get rid of clouds, to do all kinds of things that he wanted to do to make sure that evidence wouldn't be discovered. Wires and putting people together. The defendant was in jail, charged with a crime that we are trying here today, and had a lawyer appointed to him. He had counsel appointed. So all these neat little tricks that they think we can do, stop by having a lawyer, and he's charged in this case. You know, they say that Barner is a bad liar. He's bad.
Oh, him. I need to talk to him today. Oh my God, what is that? Oh my God. What is that? Is that really Offset? Look at it. Look at this. Oh my God, I'm scared. Babe, are you calling me? Oh my God, what is that?
He's a liar.
What is that?
20 minutes at the end of her closing, saying how Barner doesn't say what my client did. Why on earth, if he's lying about this, would he not exaggerate? Why doesn't he just say, yeah, I'm down for it. He told me, let's kill that guy. That's not hard to remember. I'm going to kill that guy. I'm going to do this thing. He doesn't say that because he doesn't remember it. He's not bought and paid for. He says, listen, I know he's down because he's sitting in the car in an apartment complex for 3 hours and hours waiting for this guy to get out. We're all holding guns. That's why I know he's involved. Remember, he doesn't have to say. The principal instruction is act. By word or act. He doesn't have to say, all right, let's all huddle up. This is what we're going to do. Which we did do. All he has to do is be there, clap out of the huddle. It's a really good analogy. Think about this.
That was Adventure in response to, is that a jury of his peers?
Godward's calling plays. Everyone's in the huddle. Trevor Lawrence says, we're going to run off Apple right side to ETN. Everyone goes, ready and break. Who talks? Trevor Lawrence. Everyone will. Most everyone's on the same page. We don't jump outside. We're doing all right. That's exactly what happened here. That is what the principal theory contemplates when it says word or act. Beyond and to the exclusion of a reasonable doubt, maybe the defendant is just the most unlucky person on the face of the earth. That his DNA is everywhere, that he didn't know anything that was happening, and everybody's just coming in here and lying on him. is just guilty. Beyond the exclusion of a reasonable doubt is not possible doubts. It is not X-ray machines at the airport. We talked about that in jury selection.
Thank you. And likewise.
The person who's checking X-rays has an absolute duty to confirm what these things are. Right? I don't need to do that other than the preservation of soul. The law doesn't contemplate all power. If there is a possible doubt that a gun is getting on a plane, you don't let it on the plane. That is not what the law contemplates. The law says that such a doubt should not influence you to return a verdict of not guilty if you have an embodied conviction of guilt. Reasonable means logical, well-founded doubts. That's what reasonable doubt means. Reasonable doubt, I agree, we have to get you across the river. It can mean that the boat gets wet. It can mean that there's a hole in the boat, but you still get across the river. That's what reasonable doubt is. We have to show you common sense and evidence that this man was a participant in the murder of Charles McCormick and beat and battered Ms. Buckley when he entered her home to escape the police. And when you combine all of these pieces of evidence as one and analyze Abdul Robinson Sr. and analyze Bada and say, I don't like him. Arm, they say, checks out. Then you have him by conviction. It is the same level. Proof is the same as if you steal a pack of gum and you commit first-degree murder. It doesn't change. Not proof beyond possible doubts, all doubts, shadow of doubts, but well-founded, logical doubts. That is what a reasonable doubt. And you can have pride when you convict this person. It's the right thing to do.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
He didn't prove a damn thing, man. That was a waste of damn time. But it's crazy though, because I still don't know, because man, out there it's not just normal, like, you know, like it don't matter if they didn't prove it. They just going off what it looked like. And they look at the music videos and they look at his hair and look at the way he talk on these videos. They didn't play as much as I didn't see, but at first I was like, oh, he's a little nice guy and shit. Then I was looking at his videos, I was like, dang, this dude kind of crazy. He kind of crazy, kind of wild. But still, that don't mean they prove nothing. It's still a bunch of reasonable doubt. So I don't know what's going on. Here, I got some more. I'm feeling kind of good. I'm gonna keep it rolling. I got some things I ain't played that happened in a couple days, so we're gonna get into that. I appreciate y'all being here. Make sure you hit that like, hit that subscribe. Make sure you tap in and make sure you share with a friend one time for the one time. Yes, sir. All right, let me load up the next clip.
Well, isn't this a nice surprise?
Sure, I'll say that. That's on me. You may. Court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you view, listen to, and consider this evidence. I am happy to read that instruction to the jury when they return, if we are going to address that part of the video again or in some other fashion, but I am certainly willing to do that to clarify any confusion so that they understand why the video was edited and they're not going to wonder why or think what's going on. That is not unusual, and I do that in other cases. Leaving in the portion that says KSOO, if your argument to that is relevance or cumulative, I would overrule, because it is relevant. I mean, that's what this whole thing is about, and I understand other witnesses may have identified him as being in the video, although the video hadn't been moved into evidence until now. But that being the case, that doesn't mean that because someone else has looked at that video and said, yes, that's KSOO in the music video or Hakeem Robinson in the music video, that the portion that shows him saying I'm KSOO or this is KSOO should be excluded. So.
I mean, of course, assuming we haven't had no voice authentication that the person saying I'm KSOO is actually KSOO. Just to add that to it. Your Honor, what I would ask is if you are going to give that instruction, that you would tell the jury this should have been given to you before it was paid.
Sure, I'll say that. That's on me. Witness, you may proceed.
The absence of evidence
Detective
is not
Smith,
the evidence.
we kind of left off when we were talking about investigative efforts in regards to this car that you believe was used, this Altima, correct?
Correct.
And the Altima you had learned had been reported stolen?
Yes.
Okay. And I think you told us roughly from November of 2000 and, I guess, 18?
19.
19, thank you. So roughly about 2 months, maybe a little bit over 2 months?
I can't remember the exact date, but yes, it was roughly about 2 months.
Okay. And I think you mentioned that maybe you talked to her son-in-law, the actual owner?
Yes.
Okay. Was he the one that had driven it the last before it was stolen?
No, his daughter drove.
Wait a minute, hold on. My bad, man. Let me put some respect on her name. I did this earlier too. My bad, Allie. You know, I know a different Allie, so I'm used to spelling it with an I. I apologize for spelling your name wrong. Let me fix that right now, and y'all show Allie some love, man. My bad. she wasn't even gonna say nothing. Like, bruh, you spelled my name wrong again. This ain't the first time this happened. My bad. Y'all show some love to Allie.
The absence of evidence
Let
is
me
not
fix
the
her
evidence.
name.
What?
For whatever reason, I think it was, I can't remember if it was at his house or her apartment when it was stolen. And the last known address I could find, I think he's the one that reported it stolen, which is why I went and talked to him.
Okay. But you ultimately weren't able to talk to whoever had it kind of physically stolen from them. And what I mean by that is, do you know where the keys left in the car?
No, sitting here without looking at the report, I can tell you where they were.
Okay. And I guess my real question is, did you make any effort to look for surveillance videos or anything that would help you determine who might have stolen this car?
It was 2 months, almost 2 months later.
Okay. So in your mind, just wasn't going to be worth anything?
No, we have an auto crimes unit, or I think it was auto crimes now, that's responsible for investigating that.
Did you talk to anybody in auto theft? Was there a detective assigned?
I don't recall.
Because you probably are very familiar that when someone reports their car stolen, of course it's going to be put into the KSOO database so that any patrol officer can be looking for that car, right?
That's correct.
Okay. But the number of cars that are stolen, to have a detective actually assigned, there usually is a suspect involved, correct?
I don't know the exact qualifications of when they assign cases on the crimes. I've never worked there.
Okay.
I don't recall seeing a sup from a detective at this time.
Okay. And you don't remember reaching out to anybody in the auto theft department to see, hey, I don't know if anyone's trying to investigate this, but can you coordinate with me?
No.
Okay. And you would have received all of the photographs that the evidence technicians took as they're actually searching this Altima, right?
Yes.
And I think you mentioned on direct you were physically there.
Yes.
Right? So you knew that there was this Bible found in the trunk.
I can't recall it at this time.
I think, I'm sorry, I should have done this on the break. Can I get photograph 76? Or no, I'm sorry, 96 from the Nissan Altima? I believe it would be, if we can just throw it there so that Detective Smith can see it.
Just the Bible footage?
Yes. Let me see if this refreshes your recollection. while we're looking for that particular photograph, did you also determine if this Altima, if anybody had ever hooked up their phone to the Altima?
I checked to see if the car was Burla compatible. It's not.
I'm sorry?
Burla compatible.
Okay. Meaning that a cell phone was unable to connect?
No. Like for me to download the vehicle via search warrant to get all that information, it was not compatible.
Okay. I'm sorry. I apologize. I don't understand what you're trying to explain to me.
It's Burla. It's.
Is that an acronym for something?
I'm sure it is. That's a company. Basically, you could download a vehicle's infotainment system, and it could tell you all that kind of information. That vehicle is not Burla compatible, so therefore I wasn't able to do that search warrant on the car to see all that stuff.
Okay. How about just turning the car on and seeing if there is any iPhone that's been connected?
At this point, I can't recall if we even had the keys.
Okay. I'm sorry.
I can't recall if we had the keys to the vehicle.
Oh, in terms of whether you could turn it on or off?
Yes.
Okay. You do remember that the car was running when you got to the scene on Townsend?
I don't remember if it was still running when I got there.
Okay. And I guess it was running when you got to the scene on Townsend?
I don't remember if it was still running when I got there.
Okay. And I guess ultimately the bottom line is we don't know.
Yes, that's correct.
Because you'd agree with me that people of a younger generation tend to connect their cell phones to cars to play music. Is that a pretty common occurrence in your experience, sir?
Yes, ma'am.
Now, you've kind of told us about some Instagram searches, and we heard a lot about Hakeem Robinson's account. Did you ever do any searches specifically in regards to Charles McCormick? And if there was anybody else out there making comments about Charles McCormick's death?
I don't supposed to be here. I don't recall none of that. All I recall is going back to prison.
Just search Charles McCormick and then his life story pop up now.
Okay. The fact is you never did any searches, right?
On Instagram?
Yeah.
No, Mel.
I'm sorry?
No.
No. Okay. You did, I guess, fairly quickly realize that this homicide occurred on the 1-year anniversary of the death of Willie Addison, correct?
Eventually, yes.
Okay. And I'm sure that would cause you to become at least familiar with what happened to Willie Addison, correct?
Correct.
And you would have become aware that Willie Addison was in a car with his father, or who he looked up to as a father, stepfather, Abdul Robinson Sr., correct?
Yes.
And Abdul Robinson Jr., correct?
Correct.
And Torrigan Williams, correct?
Correct.
And that all of them were shot, correct?
That is correct.
And in fact, Mr. Robinson Sr. told us yesterday there was an additional 2 people there, one by the name of Moody, goes by Antonio McLaren. Are you aware that he was in the car when Willie Addison was shot?
I believe it's Antoine, but yes.
Okay. You were aware of that, sir?
Yes.
Okay. And then somebody else he referred to as Sammy, who evidently ended up paralyzed.
I don't remember Sammy.
But it was significant because obviously you're having some allegations where Abdul Robinson Sr. and Abdul Robinson Jr. their names are being brought into this investigation specifically by Dominique Barner, and you're aware of this anniversary, right?
Yes.
And Dominique Barner was very clear that Torrigan Williams was involved in this homicide, correct?
Yes.
He told you back on August 27th of 2020, hey, you're going to want to be looking. And he names Torrigan Williams, right?
Yes.
And that would probably hold special significance because Torrigan Williams, in fact, was in the car and was shot himself when Willie Addison was killed, right?
Yes, ma'am.
Because in looking into that investigation, you obviously became aware that Leroy Whitaker wasn't in that car, right?
That's correct.
Hakeem Robinson wasn't in that car, right?
That's correct.
And Willie Addison was older than Abdul Jr., correct?
I believe he was, but I have to look at the date of birth to verify.
Certainly much older than Leroy Whitaker.
Correct?
And so, based on your conversation with Dominique Barner back in August of 2020, it was your intent to investigate and ultimately attempt to interview Torgan Williams, right?
At some point.
Okay. But that didn't happen, did it?
It didn't.
Okay. Torgan Williams, and you actually put out something called like a person of interest, right?
Yes, ma'am.
Okay. And that's in your JSO database?
Yes, ma'am.
Okay. And that's supposed to be for any Jacksonville Sheriff's Officer, every patrol officer. It's a specific note that if they come into contact with Torgan Williams, they should contact you, right?
Yes.
Okay. And I think you've told us before, you put that into the system, right?
Yes, ma'am.
And do you think you would have done that after August 27th of 2020?
It would have been around the time I became aware of his involvement.
Okay, which would have been August 27th, 2020?
Yes, around that time.
Okay. And you're aware Torgan Williams had been arrested since August 27th, 2020, right?
Because I said he's just because he got arrested doesn't mean they called me that night when he was arrested.
Okay. And he's physically in this courthouse on multiple occasions.
I can't verify any of that.
Okay. You weren't aware that he was in court on September 21st of 2021?
I don't recall anybody making me aware of that.
Okay. How about September 28th of 2021?
Again, don't remember anybody making me aware of that.
Okay. How about October 28th of 2021?
Don't recall anybody making me aware of that.
December 2nd of 2021?
Same.
Okay. How about when he actually pled out on June 28th of 2022?
Same.
And your explanation is no one contacted you and let you know that Torgan Williams, who you always had wanted to interview and were actively investigating in this case, was physically in the Duval County Courthouse.
That's correct.
Okay. Even though Mr. Atkinson was the one prosecuting him. Were you aware of that?
Vaguely, I think I might remember that. Sorry.
But the bottom line is, you didn't speak to Torgan Williams. You didn't have the kind of interview you wanted to have with him, right?
No.
The interview you had with him was in February of 2025, right?
That's correct.
And that's just something lawyers arranged, right?
Yes, ma'am.
Shout out to Outlaw Nation. Appreciate you hanging out with us.
We did see on your direct that you...
We still going. We still rocking and rolling. We got about 5 more minutes of this one, and then I got another clip or two, a little bit more. We rocking and rolling, but appreciate you hanging with us. For sure, for sure.
You were identifying in these phone records that there were calls with Torgan Williams that day, correct?
That's correct.
Okay. Which I guess would have just further supported Mr. Barner's claim?
Yes, ma'am.
So no formal interview of Torgan Williams. No formal interview of Chris Brown, correct?
That's correct.
And Mr. Barner gave you a lot of information about Chris Brown, right?
I don't know about a lot of information.
Well, were you aware that Mr. Barner claims that Chris Brown is the confidant that originally went out to the complex to make sure that Mr. McCormick was there? They went out in the middle of the night. In the early morning hours of the 15th. Did Mr. Barner explain that to you?
I don't recall that being explained to me.
Okay. And you don't remember, or you don't recall it being explained that he was with Chris Brown and they were actively talking about the benefits of killing Charles McCormick?
At some point I heard that, but...
Yo, No One, appreciate the support, but we taking a break on some of those prompts right now because it's been causing little issues with the stream. I don't know why. I'm reading into it. It's been a lot of changes going on, but appreciate you.
Okay. But you never sought to interview Chris Brown?
No. Even
though he's sitting in the Duval County Jail?
Yes, because it is explained to me that he left before the homicide took place.
Did Mr. Barner explain that evidently, according to Mr. Barner, Chris Brown came back? He came back to that complex. Supposedly, when everyone's there, Chris Brown comes back to that apartment complex. Did Mr. Barner explain that to you?
Yes.
Okay. But that still didn't make you want to go interview Chris Brown?
No.
Okay. Even though he's sitting at the Duval County Jail.
But you can drop your own link. No one, if you got a new song or something coming up, feel free to drop that. Just some of the ones we've been posting, I don't want to do them right now. I'm just testing to see if that's been what's been making this effect. But other than that, you can drop your stuff though, and anybody particular.
That's correct.
Ultimately, your decision in this case was you didn't feel you had enough evidence against Torgon Williams, right?
That's correct.
You did arrest Abdul Robinson Sr. for accessory after the fact, correct?
That's correct.
You did not arrest Leroy for accessory after the fact, did you?
I did not.
But according to you, your evidence at that time was supposedly at the Buckley home. According to Mr. Barner, he was arranging for a car ride out of there, right?
That's correct.
You mentioned there was a rifle and a handgun found in the Nissan Altima, right?
That's correct.
Okay. And according to Mr. Barner, that rifle was Leroy Whitaker's, right?
According to him, yes.
Okay. Only according to Dominic Barner, right?
Correct.
I mean, you don't have any physical evidence, right?
Correct.
Okay. We've seen Instagram photos and such. Do we have photographs of Mr. Whitaker holding this firearm?
We do not.
In fact, I did not hear you testify, sir, to any kind of Instagram posts by Leroy Whitaker, correct?
No.
And Mr. Whitaker's not in this video that we saw of Charles McCormick dancing around, correct?
I'm sorry, of him dancing around?
Of Mr. McCormick dancing around, the video that you felt was
You're referring to
the bye, bye, bye video?
No, he was not in the video.
You never ended up doing any kind of a search warrant at Mr. Whitaker's home?
No.
Never spoke to his father?
No.
And the reality is, sir, after the arrest of Leroy Whitaker for murder in this case, after you laid out your probable cause, and you told us your investigation continued, right?
Yes.
But you never developed any further evidence that Leroy Whitaker had anything to do with the death of Charles McCormick, did you?
No.
I don't have anything further, Your Honor.
All right, then we are at this time going to...
Nah, you ain't gotta delete it. It's just for future references. You ain't gotta delete it. Yeah, let's see what else we got. We got a couple more. Appreciate y'all being here, family. Let me see. Here we go. Let's get to this dude right here.
What's your current
Ain't not
rank?
that long.
Sergeant.
I want to turn your attention to January 14th of 2020 at around 3 o'clock in the afternoon. Do you remember being in your department's property room on that day?
Yes.
While you were in the property room, did you see my client, Hakeem Robinson?
Yes.
Did you sit down and have a conversation with him?
Yes, I did.
Now, the case that we have before these juries happens less than right around 12 hours later, 12 to 18 hours later. I want to ask you questions about what my client looked like.
Okay.
Do you remember what his hair looked like?
Somewhat, yeah.
Now, if we can use the gentleman here with the gray suit and the red shirt, would you agree that my client's hair was around the same length, maybe a little bit longer, but twisted.
Correct, yes. It was, I think, a little bit longer than that.
It wasn't dreads down to his chin.
No, not at all.
It was consistent with that type haircut where it's trimmed around the edges, twists.
What you think about her hair in the back? It's laid back, ain't it? She laid back a little bit. Or do y'all prefer, hold on, let me see. I got a question. Which one do y'all prefer? Her hair that you can see in the corner? Can you see it? Let me see. Boom. And let me move him out the way. Let me know which one y'all prefer.
Maybe a little bit longer.
From what I remember.
But not much longer.
From what I remember, yeah. I can't recall too much, though.
Sergeant, I have 2 questions for you. You had a conversation for what, maybe about a half hour with my client?
If that, yes.
Would you ever use the word slender to describe Hakeem?
I would not know.
What about short?
No.
One brief moment, Your Honor.
Okay. Okay. Any cross?
How?
Hey, how are you, sir?
Or maybe I shouldn't say prefer. Maybe that's not a good question. Which one, or I don't know. What's the difference? What's the difference between her hair on the right, on the left, and her hair on the right? What's the difference?
Have you had the opportunity to view video recording at the JSO property room that shows Defendant Robinson and your interaction?
Prior to coming in here?
Yes, sir.
No.
Would that help refresh your memory about how the Defendant Robinson looked at the time of your interaction?
Yes.
I'm going to show you what's been pre-marked as State's Identification 10R, the videos. They have been part of discovery. I'll show you. I downloaded it onto my computer, so it makes it easier to move around. Showing you the lobby, Sergeant Howell.
Objection. This is refreshing. The witness can look at it. Ask the question again.
Okay.
Let me ask this. Is this video taken on... Does this video...
Okay. I need to hear the question. I mean, if... Uh-huh.
Taken. The Sergeant Howell.
Objection. This is refreshing. The witness can look at it. Ask the question again.
Okay.
Let me ask this. Is this video taken on... Does this video...
Okay. I need to hear the question. I mean, if... Uh-huh.
Taken on January 14th, fairly and accurately display Hakeem Robinson when he comes to the property.
All right. I'll overrule the objection to that question. That's an appropriate question.
Right here, correct. He's got a hoodie over his head, correct.
And Sergeant, as we fast forward through that video, do we see you?
Yes.
And are you in a red t-shirt in this video?
Yes.
Your Honor, this time I would move into evidence states R.
Okay. Any objection? All right. Let me see it.
Well, isn't this a nice surprise?
All right, you ready, Madam Court Reporter? All right, ladies and gentlemen, we're going to go a little bit back out of order. We're going to go back to direct examination, and then Mr. Mizrahi will conclude his cross. Yes.
I'm sorry. Clerk first. I gotcha.
What, defense exhibit number 2?
Pre-marked as defense 3.
Okay, defense. Okay, then no need to lay the predicate. Defense exhibit number 3, which shall be marked into evidence.
Sergeant, have you had an opportunity to look at defense 3?
I don't know what defense 3 is.
All right. Did you, in the hallway before coming in here, have a chance to take a look at some videos from the property room?
Yes.
It's got you wearing the red shirt.
Yes.
Got Mr. Robinson first getting dropped off out front, walking into the facility, going inside.
Yes.
And then you having a conversation with him and him exiting?
Yes.
All right. You reviewed that before you testified?
Yes.
And in any way, did that change the testimony that you gave in here?
No, I mean, go ahead, I'm sorry.
Hair, build, height?
Like I said, hair from what I saw from the front, correct. That's what the size of what we're saying Mr. Whitaker is.
Nothing further. Thank you, Your Honor.
All right, cross-exam, continuation.
Sure, may I publish statements of defense?
All right.
Bruh.
Is this the laptop HDMI? You're good. You're good. Texas.
Lady Justice is blind. Everybody can hear.
Sergeant Howard was showing you Defense Exhibit 3. Is that the defendant, Mr. Hakeem Robinson, wearing a hoodie?
Yes.
Does Defense 3 fairly and accurately depict the way Hakeem Robinson looked on January 14th of 2020?
Yes.
A couple more brief ones. First of all, the lobby. Again, Defense Exhibit 3, is this the inside of the property room, Sergeant?
Yes, that is.
I'm going to fast forward. Just to show the jury, you're generally the same build as you were at the time?
Yes.
Meaning today versus,
What is that?
the computer
Dennis
just
Quaid?
froze up.
Okay, sorry.
Is, Sergeant, is that you in the red shirt here? And who are you talking to?
It'd be Mr. Robinson, yes, and that's me.
And then one more angle. In Defense Exhibit number 3, do we see the door here where Mr. Robinson is leaving?
Are you in the freak-off?
Oh! He needs some milk.
Can I get water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all.
Daddy, I like when you scrambling and scraping for shit.
No, I got
I
notes
like
and
that.
These 3 in the red shirt, is that you, Sergeant?
Yes.
And in front of you is Mr. Hakeem Robinson?
Correct.
Your height and weight, time in January of 2020.
Then was 6'3", 15".
Sergeant, was the defendant, Hakeem Robinson, was there to pick up a cell phone, correct?
Correct.
Have a moment,
Okay.
Sergeant, does that video change in any way what you saw with your own eyes that day?
No, I mean,
Mr. Robbins is under your skin.
All right, and we're gonna close it out with Butter Girlfriend, her interview. Let's cut this down a little bit so they don't be trying to be all on me. Dang. All right.
I'm gonna be in here long.
I hope not. I told him I'll let you talk to him too. Before we talk, I want to make sure I go over your rights with you and make sure you understand your rights.
I am going to jail.
Let's see. Janera. Janarane. Apostrophe E. How you say it again?
Johnny.
Johnny. I could fill all that out later. What's your highest level of education?
Diploma, high school.
High school diploma. So you're reading right? Under influence any drugs or alcohol right now?
You got any crack pipes on you?
Like I told you before, we had the police memorial building. We call it the PMB for short. You won't be a opponent in your car?
No, okay. I want a great scare, you know what I'm saying, for you, you know, but I'm just gonna ask him. He ain't even about that. If I go to tell him, not, oh well. But if I can not do that by talking to him and getting him to tell me something, at least saying, you know what I'm saying, yeah, then cool. But y'all could definitely search that car right now. Nobody gets in that car. I do want to ask him before.
You want to talk to him before giving us consent to search your house?
Yeah, so I mean, I know, I don't know, it's just something just don't feel right. Something just don't feel right. I just want to talk to him and ask him, you know what I'm saying? Because, I don't know, I ain't got no easy feeling. And it ain't on my part, it's just on his part, you know?
Yeah. Well, I just got done talking to him.
Go to jail after this regardless of the, you know what I'm saying? I don't want to let y'all search my shit and I'm still going, you know what I'm saying? Still go to jail. Like, hell no, I could have just stayed chill and let y'all go through the regular way. But I know if y'all get a warrant, y'all can go in that bitch without my consent anyway, right?
Yeah, we get a warrant.
Right, so
but
just to
if because the fleeing and eluding, that's not on my part.
I said the officer that. Yeah, I already know, but I just knew it wasn't for me. That's all I was telling him, and just like, if this shit gonna get me fucked up, not me here, nah. You know what I'm saying? If he just was like, shit, just stop, babe. I'm told his ass don't run, and that motherfucker still got out trying to run.
So
I gotta go to the work.
If you give consent, I'll talk to them and see. I can't guarantee anything because what happened out there, I can't really control. I
told him I wasn't going to jail. Now y'all telling me I'm going to jail, so I don't know if it's a scare tactic or what. Because that man just looked in my face and told me, you good, you know what I'm saying, you cooperating, you pulled over, you being cool with me now, you let me know what's going on. Great, you know what I'm saying? I just want to go home. Just let me look at this boy, his face, and give him a devil look and see if he going to tell me something.
He'll probably talk to you. He talked to me, and he supposedly love you. He'll probably talk to you. How you know?
I know he do. His mama look me in my eyes and tell me he won't treat no girl the way he ever treats. You feel me?
I think he love you too.
He love me.
Yeah, I wasn't in there that long, but I think he love you.
Love ain't gonna get me out this shit, man.
That's true. You sure the only clothes you saw him with today was the t-shirt and boxers? And then what he got on there? He ain't have on nothing in between?
Some great, well, that's the great boxers. Lord, I'm not sure though, cause he was going in the bathroom. Like I peeped, bro, when he came home, but I don't know.
What he had on when he came home?
Them pajamas. He had them pajamas on from Becky house.
Fuck, I think it's a jumpsuit. I think it was Army fatigue jumpsuit. I think that's what he had on. I wasn't that sleep. I was definitely that sleep.
You sure? Cause you said you was asleep.
Yeah, that's what I'm saying. But I know, cause I think the shoes or whatever in my living room. I think.
What kind of shoe?
That's some high top Air Forces.
What color?
Brown and orange. They matched the suit. And I think I did see that suit, and I'm pretty sure I did see him. I know I was asleep, but them shoes is in my living room.
Sure?
Yeah, and that suit should be that outfit should be in my house.
It wasn't a dream, was it?
No, you got me. You questioned me, got me thinking I did see him.
You was on your PMs. I don't know what you might have saw.
You know, you roll over and be like, like peep your eyes. I think he had on something orange. I think that jumpsuit is orange.
Do we have any red tennis shoes at your house?
No, we got no damn red shoes.
You got no red shoes?
No, he got red shoes.
That's what they looking for, them red shoes. Remember, even on the stand, he said he had them red shoes on. In the other interview, I got his interrogation too. He said he had some red shoes on.
They're not red though. They are they red? I think we be wearing down slides all the time. We ain't got much. We just moved back from Vegas, so we trying to build up our this man got no red shoes. He had no red shoes in a minute. What could be possibly red? My stomach's starting to hurt me again too. I need to go. Trying to think of what shoes he got. What the hell? Nah, no black pants, no
with a red and white shirt.
Oh no.
You never seen that?
I don't think black. He got us some shorts, but they ain't got no red on them. They just black, like shorts, kind of like what you got on now. Like we ain't got much for real. Like probably things for me. And
you know.
All that pretty much.
Stand up. Put your shoes on. Did they give you that blanket, or did you?
They gave me this blanket.
They gave you a blanket. Turn around, face away from me. Interlock your fingers together. Other way, like you're praying. There you go.
Or
fleeing and eluding, not stopping when you saw the police cars behind you. All right. Did you need this?
No, not no more.
He gonna say, you seen that? He gonna say, did you need this? As he dropped something inside the cup, like some trash or something off the table. She said, no, not no more. All right, and one more time, man. We gotta get this little clip of just. We out of here right now. I just want to see him look for this crack pipe.
Do you have any credit cards that aren't yours?
There's a crack pipe in the corner.
What's that?
There's a crack pipe in the corner.
He lying. Dang, Mom.
There's a crack pipe in the corner.
What's that?
There's a crack pipe in the corner.
Hell nah. there's a crack pipe in the corner. Anyway, I appreciate y'all hanging out with me one time for the one time. We up out of here, man. It's been a great one. I'll be up early tomorrow morning. I don't know what time I'm gonna start, so let me not say that. But I will be streaming the live. How you see it? He went straight over there to it. Look, like he smelt it out. He sniffed it out. Heck no, and they got a little stash spot over there. That's crazy, yo. That's crazy. Oh, my mother. Let me see. That's crazy. That's crazy. So yeah, like I was saying though, yeah, tomorrow morning, I'll be streaming. Or I don't know, man. But tomorrow morning, most likely. I know y'all like, damn, make up your damn mind. It's all good. Shout out to today's stream sponsors.
The absence of evidence is not the evidence of absence.
What?
I don't know what I'm gonna do, but I'm gonna try to stream in the morning. I'll say that. I'll try to stream in the morning. TSC, Ali, Joni Ford, Chanmar Black is Golden. Appreciate y'all. Stream sponsors of the night. No One, I see you. Appreciate you, family. FFS, I see you. Ali, what up, though? Ali with a Y, not an I. Good night. Have a good one. Adventuring, appreciate you hanging out with us. Appreciate you adventuring. Outlaw was hanging out. Outlaw Nation. Shout out to Outlaw Nation. FFS. Appreciate you. Outlaw Nation. No One. Dang, this all. They won't even let me go up all the way. Miss DB. All right. Well, that's about as far as it's letting me go. I forgot I had to refresh my chat in the middle, so I ain't got all the chat names. But other than that, I will see y'all later. Y'all have a great one. Shout out to y'all for hanging out, man. Appreciate y'all.
Have a good night. Have a good night. Have a motherfucking good ass night.
Stay fresh and stay blessed. Peace out.
He arose, never hated friend or foes, just a sub to art and not giving a fuck. Chasing down my goals, high self-law, El Master, supernatural disaster, metaphysical.
Shout out to today's #1 chatter, TSC. Appreciate you. Let me see, I think they got something where I can see all of them now.
All stay home at a club jumping. What up, cousin? I see you, fam. Throwing slime coins when I watch the trial. Leos be capping, chatting action. Come and tap in the most interactive. I am the flesh.
Crack pipe in the corner.
I am the God. I am the flesh. I am the God.
Oh my God, what is that? Oh my God, what is that? Oh my God, what is that? Is that really awesome? Oh my God, what is that?
I'ma keep going till I'm motherfucking tired. You what? I'm motherfucking tired. Slide brothers out, could we rain down game? Like, what you mean? Just watch the rise. Watch the rise. I am the flesh. I am the God. I am the flesh. I am the God. Flesh of the gods. I am the flesh.